Good morning, everyone. Welcome to the Thursday, December 11th, 2025 agenda meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben, the chair of the commission, and today we have two other commissioners present to constitute a quorum. Commissioner Hom.
Here.
And Commissioner Tuma.
Here.
We have three items that we'll hear this morning, and we'll then take maybe a recess before, depending on how the other ones take it, how long they take. But we won't hear the final three items until 12:30 p.m. or later. So we'll begin with Dakota Electric's rate case. Mr. Ubani, please introduce item number one.
Good morning, Chair Sieben, Commissioners. Agenda item number one is docket number E11/GR-24-400 in the matter of the application of Dakota Electric Association for authority to increase rates for electric service in Minnesota. The question before the Commission today is, should the Commission adopt the recommendations in the AAJ's report? Staff knows that there were slight corrections to decision option number 106 and 131. For decision option number 106, the dollar amount was corrected as $49,472 instead of $45,472. For decision option 131, part of the sentence was struck out at the phrase 2023 test year and in DEA, and instead the corrected decision option read as follows: disallow recovery of all alcoholic beverage expense in future rate cases. Staff filed two corrections on December 9, 2025. The parties are here for question. Staff had no further comment and available for question. Thank you, Chair Sieben and Commissioners.
Thank you very much. If the parties would please come forward, we'll begin with opening comments. We'll start with appearances on my right. Ms. Stasny, good morning.
Good morning, Kristen Stasny on behalf of Dakota Electric Association.
Good morning, Chair Sieben, Commissioners. Adam Heinen with Dakota Electric Association.
Good morning, Chair Sieben. Catherine Arnold, Assistant Attorney General for the Department of Commerce.
Good morning, Chair Sieben, Commissioners. Catherine Hindley with the Office of the Attorney General, Residential Utilities Division.
Okay, thank you. We do have a settlement here, but why don't we begin with comments from Dakota Electric?
Good morning again, Chair Sieben, Commissioners. Just want to start off by thanking staff for their briefing papers, and then also thanking the parties for the work that we did throughout the developing the record here, through testimony, petitions at the settlement conference, and then afterwards. Dakota Electric believes we've reached a settlement that's in the public interest and the best interest of the cooperative, and represents the best outcome for our members, resulting in reasonable rates. And certainly from a decision option standpoint, we would recommend decision option 1, and then which is accepting the settlement agreement and the ALJ's report, and then decision options 901, 902, and 903. And we're certainly here to answer any questions that the Commission may have.
Thank you. And for the OAG, Ms. Hinderly, do you have any opening comments?
Yes, thank you, Chair Sieben. Just briefly, thank you also to staff for the briefing papers. We recommend the Commission adopt the ALJ's report and approve the settlement, and that's, as Mr. Heinen just noted, decision option 1, and then the housekeeping options in 901 through 903. We believe the settlement is reasonable, supported by substantial evidence, and consistent with the public interest. It reduces DEA's requested increase by about $2.93 million and includes a significantly lower proportionate increase to residential and small business customers than what was proposed. That being said, we understand that any rate increase is difficult for many residential and small business customers who continue to face affordability challenges with energy and other necessities. In addition to the standard revenue requirement and rate design issues you find in every rate case, the settlement also includes additional commitments for future rate cases from DEA. These include confirming charitable organizations are registered or exempt from registration prior to requesting rate recovery for those contributions, and excluding certain expenses from future rate cases. Last, I want to note that the settlement was possible because Dakota Electric agreed to include significant additional information with the settlement filing to ensure there was a clear record for the Commission's review. We appreciate Dakota Electric being willing to work with us and with the Department of Commerce to provide this information. And with that, I'm available for any questions the Commissioners might have.
And thank you very much. And for the department, please.
Chair Sieben, Commissioners, the Department appreciates the opportunity to provide a brief opening statement. First, the Department would like to thank Commission staff for the briefing papers, which thoroughly reviewed the issues addressed in the settlement. The Department would also like to thank ALJ O'Reilly for her review of the settlement agreement and her report recommending that the Commission find the settlement agreement to be in the public interest and supported by substantial evidence in the record. Finally, the Department appreciates Dakota Electric's cooperation in developing a thorough record and providing additional information and documentation when requested, providing the support necessary for the parties to reach a settlement. The Department believes that the settlement agreement is in the public interest and will result in just and reasonable rates. The case is Dakota Electric's first requested rate increase since its 2019 general rate case. Although there has been significant inflation since that time, the settlement agreement limits the overall rate increase to 9.6%, with a smaller increase for residential customers. With only a few minutes for opening statements, the Department cannot cover every aspect of the settlement agreement. There are, however, a few issues the Department would like to highlight. Many items in the settlement agreement reflect the Department's frequent practice of using multi-year averages for expenses that fluctuate from year to year, protecting ratepayers and the utility alike from setting rates based on unrepresentative expenses and revenues, including adjustments for bad debt expense and utilities service revenue. The Department also supported, and the settlement included, adjustments that reduced depreciation expense and increased sales. On the issue of employee compensation, Dakota Electric worked with the Department to develop a more thorough record and appropriate test year expenses, which reflect the utility's need to offer competitive wages and benefits while acknowledging the utility's burden of proof to support requested expense recovery and the reasonableness of costs passed on to ratepayers. Finally, the settlement agreement also removes lobbying expense. The Department appreciates the lead the Residential Utilities Division has taken on this topic to protect ratepayers from paying for advocacy that may not align with their interests. The Department respectfully requests that the Commission approve the settlement agreement and is available for questions.
Okay, thank you very much. We'll start with Commissioner questions. Commissioner Tuma?
Yeah, Mr. Heinen, did you calculate, there's rate impact, bill impact? I know lots of things have happened with inflation. So just from a average residential bill impact, 5 years, 9%, that's, a pretty significantly below inflation. But I don't know what your contract is with your suppliers for energy. I don't know where that's at. So have you done any analysis what the bill impact? I'm someone sitting in Dakota Electric's territory. I was paying X 5 years ago when interim rates went into effect. I'm paying what now? Have you done that analysis?
Mr. Heinen?
Chair Sieben, Commissioner Tuma, yes, I actually had trying to think what work paper it was. I looked at an affordability metric. Actually, if you give me a minute, I'll get it out on my binder behind me. I can give a rough outline.
I'll always give you a minute, Mr. Heiden. 2? I don't know.
And you're not sure about 2? I don't think I'll need 2. Reading glasses here pretty soon.
I got these little bifocals. They work pretty good. You should.
I've heard that they're
them.
nice. Now, Chair Tuma, this will be a little high level, and also note that this would reflect the original filing. So there's obviously been adjustments. So it might be it will be a little bit lower than. Also, RTA impacts. We'll have a new RTA starting in January, so that will be some there. So forgive me while I do math on the fly here. back, and this would be in work paper 25. The average bill for member using residential member using 700 kilowatt hours a month. Their average bill in 2019-2020 timeframe was right about between $95 and $99, depending on the year. And then with the total rate impact, so that'd be the 2024 estimate, I ended up at about, that was 111, and I think the rate with the full rate increase would have been about 115. So about $15 to $20, and we end up less with the adjustments for this rate case. So in 5 years, say $10 to $15 a month, around that. Again, apologize
So
for high level math on the fly.
It's nice it's right around $100, so we can kind of say the ballpark 10 to 15% increase, which is still well below inflation for the last 5 years, which we know from previous folks in front of us is right around 19% for that 5-year period. So below inflation, and that's what I anticipated. I just wanted to make sure we're applying, because there's, the rates are one thing. When we look at energy, that's another thing too. And Dakota Electric has been a leader in, energy efficiency and that type of work. And so it doesn't surprise me that you have remained below inflation. So that's good to hear. Only a couple other things. On page 40, we talk about the large load data centers in the briefing paper, and we just had you in front of us on this. And I didn't do a side-by-side analysis of it. It was just a curiosity note that I made as I was reading the briefing papers. Is there any conflict with the settlement based on what we basically decided when we were here last on the large load discussion? It didn't seem like there should be, but I wanted to make sure we're tracking. There's no adjustments that needed to be made.
Chair Stephen, Commissioner Tuma, no, there's no conflict or adjustments needed. When I was here a couple weeks ago with the large load tariff, that's looking more to the service extension, for lack of a better term, and construction of this. This would speak to new data center load, so separate issues. No, and so there's no conflict there. If we were to add 50 megawatts or more of load between now and the next rate case, we would let you know. I don't anticipate. Actually, that would almost be an impossibility, but anything's possible, and we'd certainly let the commission know. And you probably would see an electric service agreement from us if we had a load greater than 50 megawatts added between now and our next rate case.
And I haven't been paying that close attention to the local press there in Farmington. Where is the data center discussions there at? I haven't heard anything as of recent. Do you have any knowledge, updates, not inside baseball or trade secret, obviously, but what's going on with that?
Chair Stephen, Commissioner Tuma, in terms of the Farmington site that you mentioned, is, to my knowledge, it's still pending. Is it district court? So there, as far as I know, there's been no changes there. There's also a pending site in Cannon Falls that's been gone. Cannon Falls City Council, I think, approved. What's it? I'm using an acronym, and I'm not in the AUAR. I can't remember what it exactly means. So that's progressed there on the land use side, but that's really the only update that's not inside baseball that I can provide.
In the end, the last thing I have for Ms. Hinderly, I appreciate this is a settlement, and I understand why they did it. I do view the associations that we have here a little differently than maybe, like the North Dakota Coal Association or Edison Electric or the American Gas Association. I do think they're a national association because they are representing member organizations. They're probably a little different animal than what I would bother me with regards to maybe, say, the American Gas Association, which is representing most of the utilities that are for profit. And so I would have been a little bit less worried about, knocking them out of the rate recovery 100%. And I understand why, there's give and take everywhere. And so that was probably a good give for you. And from this one commissioner standpoint, that one doesn't bother me as much. I appreciate your strong advocacy for making sure our dollars don't go towards lobbying efforts to ensure that utilities make more profits. That much I get, but with these two associations, I would be less bothered by it. So I just wanted to make that statement. I certainly want to give you an opportunity to respond, understanding this is a settlement and this is where it goes. But as we look forward, I'm not bothered by at least some of the recovery for the National Association versus, say, maybe the American Gas Association.
Chair Sieben, can I just respond very briefly? I think we agree that there's differences from the record we've seen in other cases regarding association dues generally, and this record here, because Dakota was able to provide for the MREA dues really, significant information about trainings they've attended and benefits that have come to those out of those trainings, to their members. I do think I would push back a little bit on the National Association dues. What really troubled, our analyst here was that the benefits that Dakota could point to were essentially derived from lobbying activities, right? And so there's a dual concern. One is, is it shareholder, ratepayer value, but there's also just a direct concern with lobbying in that ratepayers are paying for speech that they might not agree with. And I think that's a concern that we see on the federal level, and it's one we take very seriously, is that, not constitutional forced speech maybe, but certainly concerns about folks being forced to pay through their bills for advocacy for something they may agree with or they may not agree with. And that's why lobbying really concerns us at all levels, regardless of, the intent of the organization or whether we might agree with the position that the organization is taking in that lobbying. We don't know that the members or the ratepayers agree with that.
Yeah, that's why I agree with you 100% when it came to issues like Minnesota Power trying to collect their dues to encourage more coal in North Dakota. That's, to me, was problematic. I think the narrowness of this association and their focus on member organization interests in their lobbying is a little different animal. How you break that out and how you distinguish it, I'm sure it becomes then a challenge. What speech is appropriate, what speech is not, and sometimes it's easier to draw a bright line. I was just trying to make the point on I'm not as bothered by their speech and what they're advocating for as I would be the North Dakota Coal Association. So I didn't want to lump them all in the same coal in the Christmas stocking that we do in other ones, but I understand where you're coming from, and I appreciate the settlement. I wouldn't want to disrupt it over such a minor issue. So,
sure, Chair Sieben, if I can just briefly, I think we try very hard. Is our position at the Attorney General's office not to be making a value judgment on what speech is being presented. It's the fact that it is speech that's being presented at the federal level in the venue of lobbying that troubles us.
Madam Chair, that's all I have for questions and comments.
Thank you, Chair Sieben. So, Mr. Heinen, so I need a little bit of understanding of mechanics of your rate case and the final impact to your customers. So you're a member-owned co-op. So who is your shareholder?
Chair Sieben, Commissioner Hom, the shareholder would be the member owners that take service from Dakota Electric. They would, through their use, if we have margins in a given year, those are returned to the members based off of their usage as capital credits. Those are paid out. Right now, we're able to reach a 15-year cycle, so let's assume we have margins, good round numbers here in 2025 and 2040. The members that earn those margins will have those returned to them as part of their capital credits payout.
Okay, so given that, I think I also saw that your cap structure, so you have an equity portion. That is a then hypothetical capital. It is not third party injecting your capital to the company.
Chair Sieben, Commissioner Hom, yes, it's theoretical cap structure. The equity is coming from the membership. Obviously, we also get debt from CFC and CoBank, but in terms of actual equity, it comes from the membership.
So basically, you're 100% debt financing, and you are 100% so leveraged. How do you manage your credit rating under that circumstance and borrowing money at the reasonable rates?
Commissioner Hom, I think we'll call up our CFO, Corey Hintz. He would, although I'm an economist and do okay with these sort of things, I'll leave it to the professional to handle it.
Good morning, Commissioners. For the record, I'm Corey Hintz, CFO of Dakota Electric. In regards to our borrowing, we do within the rate case we provide our primary lenders are CFC and CoBank, and so what we do, to fund our capital structure, we can't do it entirely through rates. We do need to borrow due to timing of our revenue, and those lenders are extremely favorable to the cooperative structure based off of their cost of funds. And so we do, between the two, when we do have to take debt out, we do go out to bid for both of them. And the rates are extremely favorable, which ultimately lowers the interest expense that we do pay, favoring our, keeping our rates as low as we can.
So do you get any credit rating agency credit rating?
We are currently not rated from an agency.
Okay, so those two lenders still okay without credit rating agency, official credit rating?
Correct.
Okay, thank you. So given that structure, if there is a rejection or a denial of the recovery of certain costs in your rate case, who's going to bear that rejection, denial of recovery portion of it? So in typical investment utility, shareholder pays for that portion. But in your case, your customer is a shareholder. So left pocket is not going to pay, but right pocket is going to lose that profit. So what is the mechanics or mechanism that delivering impact from this denial in your case?
Chair Stephen, Commissioner Hom, it'd be two, if there's a disallowance, then, there's obviously not a way for the shareholder to account for that compared to a traditional IOU. There'd be two mechanisms there. I mean, we could lower cost internally. We could take out more debt financing, or, it's just would wait around until a future rate case to make up the difference. But ultimately, there's not a venue for us to deal with a disallowance in that manner. So we have a very strong incentive if we ask for something in the rate case, where we're not prone to try and well, my colleagues from Excel are here, so I'll be more polite. But we don't have an incentive to ask for what we don't think is reasonable.
Okay, so I'll ask a little more provocative than the membership do. So entertainment expense on the alcohol, so I think it's agreed to reject that. If your board members doesn't change their practice consuming alcohol and paying with the company credit card, how can we enforce it?
Chair Stephen, Commissioner Hom, the best way we can be enforced is would remind them that they're rate regulated. They have board policies. We make adjustments internally, and then also internally, the board doesn't have carte blanche on what their expenses can be, or in anybody at Dakota Electric for that matter. There will be review, and if we saw that there was a inappropriate expense in going forward, we've agreed on the alcohol expense, that would be rejected as part of their expense report, and then they would be liable for those costs.
So in that case, do you have a board policy or board reflecting this decision after the facts, creating new policy to make sure that you are rejecting certain expense due to the commission decision? Otherwise, there's no financial impact to your members, right? Because it's a left pocket and right pocket.
Chair Stephen, Commissioner Hom, to the extent a policy change is directed from the commission or the legislature for that matter, we obviously will update cooperative board operating guidelines within the cooperative to make sure that they reflect those directives and changes, so that those practices reflect the law and also the agreements that we've made from a regulatory standpoint.
So can Dakota Electric file the information in next rate case, how you effectuate any denial of the cost recovery at this rate case, and how you effectuate with the board policy or any other decision made at the Dakota Electric?
Chair Sieben, Commissioner Hom, yes, we'd be more than happy to provide testimony in our initial filing or exhibits that would help losing the word, to illustrate how we would deal with that situation.
Okay.
That's not a problem.
Okay, thank you. Otherwise, I think it is just we just shipped money from left pocket to right pocket, and I had a concern that your members may not get the actual benefit of what we are trying to do. And then these two parties work hard on that one and you settle. I think that should be properly reflected in the actual practice at your co-op practice.
Oh, Chair Sieben, Commissioner Hom, no, we totally agree. We're not in the business. So, we made a settlement, we made agreements to the parties, and, we're an organization of our word, and we will make sure that we do what we said we committed to do.
Okay, thank you.
Mr. Heinen, back to the data center discussion, and I appreciate Commissioner Tuma's questioning and just want to talk through a little more with you what the docket a couple weeks ago and then the potential data centers joining your service territory, in the future, what it means for your for people in your service territory. So my understanding is the tariff structure that we approved a couple weeks ago will set the framework for you to or for the utility to file ESA essentially when a data center proposes to come online. I have that right, correct?
Chair Sieben, yeah, for the most part, what was approved a couple weeks ago sort of sets up the framework of constructing a data center if it happened in our service territory. Obviously, you couldn't have an ESA to take service without a construction of it. So that's sort of the first part of the process of getting to an electric service agreement.
And what, both now and then later, after we approve an ESA, a data center that comes online now, what class of customers do they go in?
Chair Sieben, are you thinking about just a data center in general or a hyperscale data center?
Would it, say it's above 50 megawatts, would it go in your general service or like your residential class or commercial and industrial class? And then do the benefits accrue to that class only?
Chair Sieben, assuming no changes to rate structure, we have other, I'll use negotiated or special rate riders, but we'll ignore those for this case. Let's just say I want regular service. If they were over 50 megawatts in their commercial, they would be on general service, which is our rate 46. There are options for interruptible service. They could also be on a commercial industrial interruptible. That probably wouldn't happen, but that's also a possibility they could have there. So those benefits derive through regular rates, go to that rate class, and then obviously the apportionment of revenue overall, depending on, I would say for a data center with that level of usage, it would probably be an overall benefit to the entire membership, but it would first have its deriving benefit to the general service class and then the ancillary classes.
And so that would mean, but because you've committed to filing an ESA prior, those terms could be modified, I assume, in the ESA.
Chair Sieben, yes, I would, just at a high level, without looking into a rate study, but from a conceptual basis, the usage pattern for a large data center is probably not well aligned with the standard general service, which is part of the need from an ESA. Our strategy on that would obviously to make sure that that member is paying all of its direct cost. There's not a subsidy from the rest of the membership. So the ESA would be tailored to reflect their cost of service, making sure they're also dealing with their incremental costs, their full costs, and also the other costs that they might exert on other parts of the membership. A good example would be if the usage is large enough that it would move us over the 4, I always can't remember if it's 4 billion kilowatt hours, whatever the FERC threshold is, that we'd have other potential requirements that we'd have to from a regulatory standpoint. That would be an example of a cost that if the cooperative has to bear that because this member moved us over that threshold, we would assign those costs to that member because they're the reason why we have those extra regulatory requirements.
The interesting thing in your response, and I appreciate it, is just that there's flexibility in terms of what rate class the customer could go in, it seems, right? And then for us to be able collectively to help persuade the public that the benefit of those increased sales would spread out to all of your membership, I think there still needs to be further discussion and, deliberation between parties over how those benefits would be distributed across your membership.
Chair Stephen, if it gets to the point of us filing an ESA, I mean, 100%. We have the electric service agreement statute. I'm not a lawyer, so I'm not going to try to quote which one it is, but there's certain requirements there, and we would make sure that it satisfies those requirements. And also, I want to make sure that we explain so that the public and the membership clearly knows that there's benefits from this load if it materializes. Because that's, our sort of corporate philosophy here with these sort of loads, not just data center, but other really large loads is, there's obviously an obligation to serve, but we also don't want to be in a situation where serving load results in negative impacts to the rest of the membership. So we don't see that as equitable or also being a part of 216B if we're dramatically raising costs or impacting reliability for other members.
Yeah, and that would apply to, I think this conversation speaks to the need for an ESA in general and the opportunity for the commission to review it and to have parties weigh in on it rather than just lumping big customers into the general service class, for example, and then not being able to have some type of proceeding where parties and the commission could weigh in on that, which I think you were essentially saying.
Chair Sieben, yes. No, and that's what I've communicated to any large load is that it's going to be an electric service agreement. It's going to have to go before the commission. So that's been my outlook and how I've expected something like this to happen for now over 2 years that we've been dealing off and on with these sort of customers.
Whether or not it's above 50 megawatts too?
Chair Sieben, I haven't, I'll be honest, I haven't operated from a threshold here. I mean, it's kind of like, what love is when you see it sort of thing. But it's a little cheeky, my apologies. But there would be like a certain threshold. I won't want to go and say what the number is, but there's a chance it could be even under 50 megawatts. We would be looking at an electric service agreement if it looks like a prospective load isn't really fitting well into our bucket of existing rate classes or rate riders that we have.
And I think that that's consistent with like having an ESA hearing for a particular addition would be easier than doing a full-blown rate case again, or calling you back in for a rate case. Obviously, we're not wanting to do that, and you don't want that either. So just as these potential large loads come into your service territory, I think it's important that we continue to have meetings and talk about this and work cooperatively to ensure that the benefits would accrue to customers if they do come to fruition. So, any comments or from the department or the OAG, since you were involved in the docket a couple weeks ago too, on that discussion?
Thank you, Chair Steven. I think one thing I just would clarify is I think the timing here is what's getting the commission a little confused because you send these to the Court of Administrative Hearings and then you don't hear from us for a while and we come back. So these recommendations were made before the 216B.1622, and I think I got that right, large customer statute was passed at the legislature, and the settlement was, signed, I think, right around that same time, and before Dakota had really, we had engaged with the proceeding you saw a couple weeks ago. So this is simply a backstop of, in the absence of having a more specific regulatory framework that I think we have now, this was just a notification requirement to ensure that the commission would kind of know what was going on in Dakota's service territory. I agree with the importance of continuing the discussion. And the one thing I would note is just, I think the cost allocation is what we're really concerned about in this. And an ESA without, additional guidance from the commission often doesn't comment on cost allocation. So that's why we see the really, important piece of ensuring that customers are benefiting from revenues coming from new large load is going to have to occur in a class cost of service study and then revenue allocation at some stage. So I think that's why, as much as we don't like rate cases, we want to kind of continue to emphasize that kind of reshifting of fixed costs, not just incremental costs, is what's going to really be required for residential and small business customers to be protected and potentially benefit.
Anything else?
Chair Steven, I don't think the department has anything to add to the information that was just offered by the other parties.
Okay, thank you. Any other questions from commissioners? Otherwise, Commissioner Tuma, do you have a motion?
I do, but before I make it, I just want to know from Commissioner Hom, did you want a 905 giving instructions for the next rate case, or are you satisfied that our two advocates will press the issue?
Thank you, Chair Steven. Commissioner Tuma, yeah, I think the Dakota Electric is one of the entity I can trust with the word, not the written order, because they are really looking after their own member, which is their shareholder. So I think there's no conflict between customer and shareholder in their case. So I don't have much concern. I think it is all about trying to do better for their members. So I think they will do it. I can take their word.
That's a good point. I mean, my concern with regards to dues, essentially the members are still going to pay because they're going to get less of a dividend check. Which, oh, by the way, my son, who works at Old National Bank, which is in your territory quite a bit, he hates Dakota Electric Dividend Week because it seems like a lot of your members, particularly in the older community, like to show up to the bank and always want cash. They want it to be cashed out. And so his request was, make it an even number next time so I don't have to give them like pennies next time. So just so you know.
We'll take that back to the board, actually.
The penny's going away, though, too.
I know the pennies are going away, so you have to round it to the next nickel, I guess. But, Madam Chair, I would move decision option 1, 901, 902, and 903. I don't think we need 904. I'm looking at staff because we have made no changes, so I think we're good with that motion, correct? I'm getting a nod of affirmation, so that's my motion, Madam Chair.
Thank you, Commissioner Tuma. I support your motion. Commissioner Hom, any comments?
Thank you, Chair Steven. We should learn how they can borrow money at that cheap. I think so. Your borrowing rate, which is well below our IOU, can borrow at the market at this point. And I'm very impressed, and I really appreciate how you managing your company.
Thank you. On Commissioner Tuma's motion, Commissioner Hom.
Yes.
Commissioner Tuma.
Yes.
I also vote yes. The motion passes 3-0. Thank you, everyone, very much for your work.
could probably come up.
Yeah, if the parties for the next two items want to come forward, you're welcome to. Okay, please introduce are we introducing both items or separately? Why don't you introduce both and then we'd have them, they're kind of together anyway, if that's okay.
Good morning, Madam Chair and Commissioners. This morning, before the Commission, we have item number 2, docket number G-002/M-25-259, in the matter of Xcel Energy's petition requesting reaffirmation of affiliate interest arrangement accounting treatment. The question before the Commission is, should the Commission approve Xcel Energy's request for reaffirmation of affiliate interest arrangement accounting treatment? Parties and staff are available for questions. Thank you.
And Ms. Nikitas.
And good morning, Chair Stephen and Commissioners. Item number 3 is docket number G002/M-23-518 involving Xcel Energy and the matter of Xcel Energy's natural gas innovation plan. The question before the Commission is, should the Commission approve Xcel's compliance filing and allow it to proceed with its Sherco 5-megawatt hydrogen electrolyzer pilot? Staff is available for questions.
Great, thank you. We'll begin first with appearances from the parties.
Good morning, Commissioners. Lauren Steinhauser on behalf of Xcel Energy.
Good morning, Sydney Lieb with the Minnesota Department of Commerce.
Catherine Hinderly with the Office of the Attorney General, Residential Utilities Division.
Okay, thank you. For both of these dockets, I'll just start by explaining my rationale for my decision option here that the parties, I assume, saw because it was filed yesterday. Essentially what it's the CBIN New 12 for folks who are watching online. Essentially what I was thinking is the Commission did approve the electrolyzer pilot in the NGA plan. In reviewing the record and the information, the compliance filing that came in from Xcel, or the 2 compliance filings that have now come in since that decision, I think it would still be interesting to hear from parties about their position and, how the pilot was modified slightly due to different variables changing around the production tax credits and other issues. But I think overall, the pilot is still consistent with the goals of NGIA, and the Commission should move forward with approving the pilot or this particular electrolyzer pilot. And the cost recovery mechanism, again, that was first submitted in NGIA about how only the commercial class would pay for the costs associated with it. I'm fine, or think that we should continue to do that. And I was also comfortable beyond my new 12 with decision option 11, which would require Xcel to include their fuel-related cost information in future filings in this docket. Because the way I looked at both of these records was that the Commission still expects and anticipates that Xcel will purchase the electrolyzer. I am cognizant, and nothing has changed, that there is one industrial facility that is an off-taker of the steam at the site. And then my new 12 is attempting to get at if for some reason that contract would leave or no longer continue its plans for service to purchase the steam, then at that time there would be a filing by Excel for what to do with that steam and how to associate the costs later with that steam contract and the future cost recovery for the remaining dollars that are left on the electrolyzer. And so at a high level, essentially what my decision option is doing is attempting to say to Excel, like, go ahead, purchase the electrolyzer, continue to operate it as you outlined in NGIA. The associated costs of that production of the hydrogen that's blended in are recoverable under, as demonstrated in the pilot and in our past order, would be recoverable from customers. And we really expect and anticipate that through NGIA and through that pilot, you will report on the challenges of operating the electrolyzer, and also in future NGIA plans, talk about the learnings and why it's good for customers, industrial customers, to pay that premium for the hydrogen blended gas. So, Ms. Steinhauser, first, will you please tell me what you think about number 12 and if you have any concerns with that or any different way you're looking at these two dockets combined. And maybe you could also briefly highlight like the changes from my earlier question, the changes in the federal tax policy or other things that have changed since we approved the pilot in the spring that kind of changed the overall budget too, if you know.
Thanks, Chair Sieben. On the new 12, the company supports that and agrees that's a reasonable way to address some of the concerns that have come out of this docket, so that you and stakeholders have the information you need to understand what's happening with the off-taking of the steam. A couple points that I was hoping to clarify that came up in the briefing papers was related to, like, the steam customer isn't benefiting from the pilot. We have confirmed that were the steam customer to go away and the coal plants to be retired, the heating that's required for the buildings after 2030, that alone is sufficient for us to run the electrolyzer enough to get the learnings that we're looking for. I know that was a question that came up. So we support the new decision option and think that moving forward in that way makes a lot of sense so that we can get this pilot off the ground. To your question about changes, to the extent this is what you're talking about, we will have to have construction started by January 1st, 2028. We have tried to build back what the timing looks like for that, and we would need a decision by March 2026, it looks like, in order to do everything that would be required to hit that construction by date.
You mean like a decision beyond our decision today?
Like a written order from the commission to
by March.
Yes.
Yeah.
I do not have any information in front of me right now about a change to what that would do to the budget. So from like a pilot planning perspective, there are no material changes to our plans for the pilot.
So I was thinking that there was a change, and maybe I'm just mistaken or read this earlier and am confused, that the production of the hydrogen blended gas, that there was a difference in a change in the production tax credit law that would influence the cost of the blended gas. But I don't know if I'm mistaken or not.
Chair Steven, I'm not that I'm the big change from the bill was to the construction start by date.
Okay.
I am not getting any information that the cost has changed to the extent that we're happy to report on that if that is something that you're interested in. I can confirm, but I don't have anything in front of me today that would say that that has happened.
That the cost of the gas has changed, right? Okay, it's good to know. And you'll be giving, under your decision option 11, which I think you agreed to, you'll be giving the fuel-related cost information annually in the docket anyway, too.
Correct.
So we'll see that.
Correct.
Dr. Lieb and Ms. Hinderly, your response to what I proposed and the path I laid out here, please.
I'll go first since we're the challenger here, I think. Thanks for the question. I think one thing I just kind of want to reset the frame in here is we're really concerned about the affiliated interest agreement, not between Xcel and Liberty Paper, because there isn't an affiliated interest agreement between Xcel's regulated entity and Liberty Paper. It's Xcel's relationship with its unregulated operations. So the benefit is flowing to Xcel's unregulated operations.
The benefit of the affiliated interest agreement, or the
benefit of the hydrogen. And so one thing I just want to, I think it'd be helpful just to read what Xcel stated in 2019 when they came in for their new affiliated interest agreement. And I quote, "Company shareholders will make the necessary investments and assume all business risks associated with the operations. Ratepayers will not be responsible for any risks associated with supplying steam to LPI and will not incur any increased costs," end quote. And so what I think the hydrogen electrolyzer addition here, which is going to be funded by ratepayers, by industrial ratepayers under your current order, what I think that does is it really changes the risks that ratepayers are being exposed to, from the risks of the steam operations that were approved in 2019. And what we're asking is that the Commission clarify that these new risks also need to be borne by Xcel's shareholders. So those include risks like, the risk of trying to attract a new steam customer should Liberty Paper cancel their contract. The risks of transporting, the cost of transporting the hydrogen electrolyzer to serve another area. These are the risks, the new risks that are coming out of this change in the structure. And I appreciate what you're getting at with New 12, Chair Sieben, but I think we're concerned that simply putting off the determination on those risks really exposes the customers to potential for increased costs in the future, and exposure to potential for increased costs is a risk.
If I can just try to understand your argument a little better, Ms. Hinderly, so you're concerned that if Liberty Paper goes away and stops buying the steam and that contract, that the electrolyzer pilot's learnings will stop, because the Commission already determined in NGIA that having an electrolyzer pilot could potentially benefit, and we should learn from what the production of hydrogen via an electrolyzer could do for industrial customers, for example. So I'm trying to understand what your real concern is. Is it that the costs of the electrolyzer itself could be stranded, or is it that the learnings aren't significant, which I know you argued that earlier, but we already decided to go forward with the pilot. So,
Chair Sieben, just to clarify, we didn't oppose the learnings from the pilot, actually. Our concern was ensuring this affiliated interest arrangement got worked out, and with appropriate cost allocation to protect residential and small business customers. But I think what our concern is here is, I appreciate that Xcel came in and said, look, here's some ways we've thought of to mitigate the risks that we presented, the risk of canceling the contract is really our primary risk. And Xcel, to their credit, did some thinking about it and thought of some ways to mitigate those risks. One of them is finding a new steam customer in the area, one of which is moving the electrolyzer to another location. If that comes to fruition, there's going to be costs associated with those actions to keep the learnings from the pilot flowing and to keep the electrolyzer in service, which I think is to everyone's benefit. But we're concerned that those costs from those mitigation efforts is part of Xcel's previous commitment that its shareholders were going to be bearing all the costs of this steam relationship, that those will then be put on to customers. So we would ask that if decision option 12 is where the commission goes today, that the commission clarify that any costs related to transporting, decommissioning, recommissioning, or interconnecting the electrolyzer in that scenario would be borne by Xcel's shareholders in their plan that they would put forward at that time.
I think that is kind of like consumed in my decision option 12 by having Xcel come back to us when there is a change. And then it seems speculative to me to say, like, we don't even know if it needs to move or not, what those costs would be, who the potential off-taker of the steam is. So, yeah, we want to know what they are, but why would we determine that now
I think because
versus just requiring them to file when there's a material change?
Thank you, Chair Sieben. It's a good question. And I think the reason is because when we think of risks, which is what the Xcel shareholders said they would take on here, the very potential of the future possibility of paying for something, that's a risk, right? Risks are in their nature speculative. So what we're asking is that the commission call out certain identified risks in this record that it is being clear that Xcel's shareholders will bear, because I think that it's difficult, we don't think these are near-term risks. These are long-term risks. So having a really clear record about what the expectation is from the utility when they come forward with this plan in a written order is really beneficial. So we're not getting into back and forths in 10, 12 years about what the commission's intentions were. I know the utilities really appreciate it when I, cite to a timestamp from a commission hearing to try to support our position. So we're trying to avoid that situation where it's really clear in the commission order what is expected of the utilities, and that these additional costs that might be needed for this mitigation member are not being shifted onto ratepayers.
Okay, thank you. And Dr. Leap.
Chair Sieben, Commissioners, the department agrees with everything that was just laid out by the OAG. Specifically, we'd like to acknowledge that the revenues from the steam sales are fully benefiting Xcel's shareholders. So the benefits of the steam sales to this customer are fully flowing back to shareholders. The steam itself is generated by a auxiliary boiler that is being paid for by ratepayers. We are now looking at adding a hydrogen electrolyzer that will be paid for by ratepayers to provide fuel to an auxiliary boiler paid for by ratepayers to generate steam to sell to a industrial customer where those steam sales will not provide any benefit to ratepayers and will provide full benefit to shareholders. In the event that the steam customer goes away, we'll have a stranded asset problem not just for the electrolyzer but also for the boiler, which is not being discussed here today, but the department wants to highlight how concerned we are that we have an unregulated business providing benefit and revenue to shareholders, and at minimum, we should be making sure that we are providing adequate protection.
So what decision option did you support in your comments then, Dr. Lieb, that seemed to mitigate this tremendous risk that you suddenly seem to be expressing a lot of concern about here? What is your decision option that I didn't mention that you now support?
The department, as noted in the staff briefing papers, supports 2.
Because can you just walk through what those would do differently than what we just discussed?
So we appreciate Chair Sieben you putting out 12, but we are concerned that this kicks the can to make determinations about who's paying for the stranded costs, or at minimum the costs to move and interconnect the electrolyzer at a new steam customer. And we feel that right now is the time to make that determination. If we're approving the pilot, and the pilot was
we already approved the pilot.
It was approved with the condition that Xcel would file an updated affiliate interest agreement.
Right.
And they did not adequately update the affiliated interest agreement to provide the protection for ratepayers that both the department and the OAG wanted to see. So we're coming back here to say that we appreciate Xcel making the filing, but it's not sufficiently protective. And so before we are going to approve the pilot, we would like to see an affiliate interest agreement that is sufficiently protective.
So number 2, then, you essentially are saying now we should determine after the 5-year pilot ends that the remaining costs are borne by Excel shareholders?
Chair Seaman, I think the intention of the department's recommendation is that only if there's a stranded asset cost associated with the electrolyzer. If it continues to be there and generate fuel to generate steam, then it's okay. But if the steam offtake goes away and there's no need to generate steam anymore, then you're going to have an electrolyzer sitting there doing nothing.
Okay, and then that is number 2, and your other decision options you now support?
The department would support 3 or a slight preference to 3A, 4, 6 with some modifications that might be offered by the OAG, 9, 10, 11, and 12.
Okay. And regarding my 12 or my new 12 or whatever number it is, Dr. Lieb, you said you thought that might be a good idea, but now it sounds like that wouldn't necessarily be consistent with your other recommendations, or do you support it?
Chair Sieben, the department supports the new 12 as not as an insufficient recommendation. So we would support 12 to provide the filing on how they want to deal with the costs, but we think that in order to approve the pilot, we need an affiliated interest agreement that provides the protections in the additional decision options that we're supporting.
Okay. Thank you. Commissioner Hum.
Thank you, Chair Stephen. Okay, let's see this in the perspective of Excel affiliates. Is Excel affiliate getting any benefit from this project?
Chair Sieben, Commissioner Hom, there's no financial benefit to the customer. However, the customer is receiving steam.
No. I mean Excel affiliate, non-regulated affiliate. Is it getting any benefit from it?
Yeah, go for it.
Chair Stephen, Commissioner Hom, if I might. I think, so the benefit is from the boiler for Excel. They use that to generate steam to sell to their customer. They get to pocket the revenues from that. The hydrogen pilot, what it does is it continues that benefit, but with increased risks for ratepayers. Some of those risks we're not disputing, right? Which is if it's some of those costs we're not disputing, which is it will be in service, it will be charged to Excel's industrial customers, and as long as it's providing hydrogen, there's some learnings from that. The benefit I think that Excel's affiliates get are, one, they get to have a hydrogen electrolyzer, powering their auxiliary boiler. I do think there are some public relations benefits to that. And I also think that what it allows them to do is to not, strand any assets with the Sherco plant and the Sherco facility. So they're able to kind of continue this transition away from having the Sherco plant online through modification of their contract in 2019. That's what the auxiliary boiler did. And now adding the hydrogen electrolyzer allows them kind of some additional mitigation of that by having a non-carbon fuel source to allow them to reach their net carbon vision. So I do think there's benefits to Excel Inc., to Excel's affiliated interest. I don't think they have to. We haven't quantified them in dollars and cents, but there are real benefits there.
Okay, so in your view, Excel Inc. cannot operate their steam without this electrolyzer. I think they already have a natural gas pipeline, and they're already using the natural gas to burn it. And then because we cannot get the 24/7 electricity from the solar panel, so I think they have to use natural gas no matter what.
Chair Stephen, Commissioner Hahn, my understanding is it's going to be a blend. My understanding is that Excel Inc. has a vision to reduce their carbon emissions, right? So they are benefiting, but in pursuit of that vision, to reducing their carbon emissions by having the electrolyzer online.
So you think Excel Inc. will claim the carbon credit out of this electrolyzer?
Chair Stephen, Commissioner Hom, I don't know that they'll claim the carbon credits. I anticipate that they will inform shareholders that this is a project. I anticipate that they will inform the media that this is a project of theirs, and I anticipate that it will be part of their overall, public relations.
So you worry about this cool thing. It's not a financial impact. Since it's a cool thing, Excel Inc. will claim this is a cool thing. So that is a benefit they are getting it. But isn't it this NGIA originally intent have this kind of pilot to prove that whether it's a cool thing or not and it's a viable? So that's why I'm confused this argument between what Excel affiliate is getting benefit from this project. I think it's a more of Excel Natural Gas is taking a risk of running this pilot. We already approved that one. We already took that risk. What additional risk we are talking about on this beyond this, our approval of this case? I had a little concern with a different reason with this case during the deliberation, but that's a separate issue. But now we approved. What is the risk Excel affiliate is trying to create in addition to what we already approved in this case?
Chair Sieben, Commissioner Tuma, first off, Excel approved the pilot subject to the condition for why we are here right now. I want to make that clear. That was a condition. It was in 2 separate order points. The condition was that Excel file an updated affiliated interest arrangement to protect from these risks. Second, I would take issue with, I don't think the NGIA intends to simply build cool stuff and in order to learn from them in the absence of their connection to retail natural gas sales. In my view, this is pushing the limit of retail natural gas sales. Excel is building a hydrogen electrolyzer to serve itself. I don't know whether that's retail natural gas sales or not. What I do know is there are increased risks to all customers, and that there will be increased risks to residential and small business customers, which the Office of the Attorney General is charged with representing, if Excel seeks to mitigate any change to the current steam arrangement by moving the electrolyzer facility, by reconnecting it, by decommissioning it, or by taking several other actions. So what we are asking the Commission is to make it clear that because Excel was the one that proposed using their hydrogen portion of the NGIA, not to experiment with providing hydrogen into their system as a whole or providing hydrogen directly to an industrial customer, but instead providing hydrogen to itself, to its affiliated interest that earns profits from selling steam to Liberty Paper. So what we're concerned about is ensuring that potential additional costs are not going to be borne by residential and small business customers 10, 20 years down the road.
Okay, so let's remove Excel Inc. from that middle. So let's put the third-party company in the middle. So if this pilot comes to the Commission as an NGI pilot, they are selling this hydrogen to that third party, and third party is providing this heat to the Liberty Paper. Do you still oppose this one because Excel ratepayers not getting, Excel Inc. is not getting any benefit from it, right? Now we remove Excel Inc. from that in the middleman. Now we put the third party, totally private. We put the contract between Excel, natural gas, and that third party. What is the reason you want to oppose this pilot?
Chair Sieben, Commissioner Hom, I think that hypothetical pilot that you came up with has a lot of the same risks that people raised in this, right? Which is that the hypothetical customer could cease operations. If it's being provided directly to the customer, there's not kind of the increased contract ability to simply cancel steam sales. I think there are additional risks with the scenario. Would still be risks with the scenario you laid out. I'm recalling in the NGIA record, however, that Excel stated when folks like us raised this risk that, well, there's other opportunities to provide steam to these Sherco, these other buildings. on the Sherco campus, right? So that was all in the record that was approved with this pilot, was these alternative potential uses for Excel's electric operations, which is not wholly unconcerning to us, but is less concerning. So, I do think it's a different pilot, but I have trouble, I think folks would have raised additional concerns with the hypothetical scenario that you are laying out of having a pilot that is solely to benefit one private customer, whether that's Excel's unregulated operations or whether that's a third party.
Yeah, that's what I meant. This is nothing to do with the Excel affiliate interest. This is about original pilot risk we are litigating here. There is a same risk regardless whether it was Excel Inc. is buying the gas or the third party is buying gas under this pilot.
Chair Seaman, Commissioner Hom, I think the difference is that when the commission allows public utilities to interact with their affiliated interest arrangements, right, with their unregulated operation, there's a concern about self-dealing, right? That's what we always talk about. We say there's a self-dealing concern, we're concerned about that, because if you have unregulated operations and you have regulated operations, that's not like a market relationship, right? And here that's what we have. We have Excel proposing a single hydrogen pilot that works with its unregulated operations. And so those self-dealing concerns are very prevalent, right? They are different than a normal market relationship where, say, Excel went out to a third party and worked with them. And so I don't think that this is exactly the same scenario. We have a utility that has proposed a pilot to work with itself in a way that provides what we see as actual benefits to sell steam and then have their shareholders profit from those steam sales.
Yeah, I think we already asked and answered on this part. You said there is no financial benefit. It is only about bragging rights about the cool thing at the corporate level.
I believe Dr. Lieb has some concerns on that. I don't understand. I will. She's the carbon credit expert, so I'll let her take that
carbon credit is a different thing. So that has to be in the different bucket. We are only talking about whether Excel affiliate is getting financial benefit from this.
Chair Sieben, Commissioner Hom. Companies across the world, many of the Fortune 500s in Minneapolis, we have this enormous sustainability network of Fortune 500 companies in Minneapolis. Companies invest money in sustainability not because it shows as a dollars and cents on their financial ledger at the end of the year. It's because of non-market strategy benefits. It's a very common investment that companies make. Making investments in non-market strategies such as corporate social responsibility around environmental commitments allows them to avoid regulation. It gives them a lobbying strategy. It is a very rational business practice. So even though there's no clear dollars and cents financial benefit to Excel affiliate, there is a non-market strategy ESG benefit that has a qualitative financial benefit that I can't sit here as I'm not an economist, so I could probably bring you an economist who could answer this with some sort of rough value of what it is, but companies across the world spend billions of dollars on non-market strategy in the CSR space, and that is what this is.
So you think Excel Natural Gas and Excel Inc. can both claim this credit. So NGIA is not about just cool thing. It is a cool thing to reduce carbon, and then it should be economically viable in the future. So that's why it's a pilot. Excel Natural Gas is supposed to claim this credit, right, under NGIA. If they don't claim it, they fail at the entry point of this pilot. So Excel Natural Gas will claim that carbon credit. You think Excel Inc. or the affiliate will have a secondary claim on that carbon?
Chair Sieben, Commissioner Hom, I think optically, both Excel Inc. and the steam customer, who now is able to say they're using decarbonized steam to produce their paper, while they cannot on a ledger or in any sort of carbon market double claim the credit, nothing is going to stop them from claiming non-market strategies CSR value.
You think market like a EU, let's say, I don't think they'll import this cardboard box from recycled paper. Let's say, assume they're importing. Do you think they will just take the claim and then they will just say, oh yeah, you claim it, so I'm going to give you credit? Or do they want life cycle of the carbon and then accounting and then tracking system to track it?
Chair Sieben, Commissioner Hom, I appreciate that you brought up the European carbon market because I think that this is where as another opportunity for the Excel affiliate to benefit from this pilot, which is that while this steam customer may not be able to claim a carbon credit in an EU carbon border adjustment tax, but Excel getting these learnings from these pilots may allow them to blend hydrogen at another industrial customer and give that carbon credit to that industrial customer who then can export something and decrease their carbon border adjustment in Europe. So the learnings from the pilot will benefit Excel affiliate to the extent that they have steam sales to other customers in the future.
So let's say if Excel Natural Gas claim all the credit and they keep that tracking system on their own system, you don't have any concern, right?
Chair Sieben, Commissioner Hom, the department still has concerns about in the event that the steam customer goes away. I think it's very reasonable for this commission to require shareholders who are getting all of the benefits of these steam sales to pay to move and interconnect the hydrogen electrolyzer at another customer.
Okay, that's another argument. We are only talking about carbon credit issue. Now carbon credit issue is if Excel Natural Gas maintain that carbon credit, so no one else can claim the carbon credit, do you still have a concern where this third party is enjoying this carbon credit?
Chair Sieben, Commissioner Hom, in this instance, no. The carbon credit will stay with the company for NGIA carbon reduction reporting. But I think the learnings of being able to blend hydrogen for industrial boilers will benefit Excel affiliate and other third-party customers.
Okay, so I don't know whether real intent of legislation, but I think NGIA, we do this pilot and learn the things, and I was hoping even Excel Natural Gas and Centerpoint to share this experience and do better job and cheaper way to reduce carbon in their own footprint. I don't know if it's a legal understanding, but my personal understanding. So that's why having this pilot, if it becomes successful and everybody learn from it, don't you think it's going to help our goal to decarbonize industrial buildings and industry?
Chair Sieben, Commissioner Hom, I don't think the department is arguing that this pilot doesn't provide overall societal benefit. Our argument is simply that shareholders are benefiting from this affiliated interest agreement in this unregulated business, and we think it's reasonable for them to take some of the risk of the project as well.
So you think buying and selling this hydrogen will give them certain proprietary information so they can get the benefit of it?
Yes.
Okay.
And Dr. Lee, before we go to Commissioner Tuma, I just want to call to your attention and to the public, whoever's watching this, that the commission, when we last approved the steam sale contract, we adopted all of the recommendations of the Department of Commerce for the affiliated interest agreement between the Excel and Liberty Paper. And so it seems like a lot of your concerns are with that past approval of the affiliated interest agreement, which in my I'm not fully tracking like the anxiety over this adding that hydrogen electrolyzer now when the terms of blending the hydrogen into the steam that's being generated won't benefit Minnesotans, especially the industrial customers where the costs are going to be attributed to under the terms of the pilot here. But that's just something else that was in the record that I think is worth noting that is pertinent here. We're not suddenly like making a dramatic change or doing anything that hasn't previously been approved by the commission.
That's a
Commissioner
good point, Madam Chair, and
Tuma.
I want to focus on what the order language said, is that we needed to review the affiliated interest agreement to make sure it is protecting ratepayers. Affiliated interest agreement that was approved by the commission in 2019 without knowledge of an electrolyzer, and so there was some questions of whether those or concerns exist under the existing agreement. Are we protected? And so, Ms. Steinhauser, I'm going to, and I apologize, you're going to have to suffer through Commissioner Tuma in his office with his whiteboard. So, Mary, if you could put up the first of my whiteboard drawings. It's very, you can hand them out to MJ. You can enlarge that on the screen too, MJ, before you. I had to get my brain around this physically in my brain, how this is operating, so that I can make sense of, and you'll get something handed out to you that looks like what you see on the screen. So that I could apply it to the affiliated interest agreement, which I read, which is a lot of the pertinent points, Ms. Steinhauser, are trade secrets. So I want to be extremely careful in what I say and how I say it. But let's just imagine for a minute a world where there's no hydrogen electrolyzer. So ignore everything that says hydrogen and back, okay? And as it sits right now, this is how I believe operationally this plant was designed to work. And I'm going to step through some of the history. My understanding is you have natural gas that goes to a natural gas boiler that is shut off most of the time. And the reason it's shut off most of the time is that you have a coal plant sitting right next to it that has burners that are on. Okay. As this system was designed originally, there was always a burner on, I think, in that coal plant. This is prior to seasonal, dispatch. We designed Sherco to have multiple boilers going, and it was envisioned that there would probably never be a boiler not going. Okay. Being prepared to charge up, but it was also providing heat to the plant. Okay. And I don't know if there was a gas boiler there always. That's my first question. As backup, because you need to start the facility up, you need to have heat in it. We're in Minnesota, it gets cold. If you haven't noticed, it's been a little chilly lately. It's going to get more chilly, at least according to the forecast. And so my understanding, as my guess was, but I don't want to make an assumption, that there was always kind of a gas boiler there at some point, needed to be there just for emergency circumstances. This is before Liberty Paper existed. This is just the way the place was designed. Is that assumption correct?
Ms. Steinhauser.
Chair Sieben, Commissioner Tuma, I'm going to see if I can get a nod.
You can even bring up your people that actually know this, because
That is a
two
great
attorneys talking about this is going to be dangerous. This is me. If I'm sitting in my office, I'm asking the person who runs the factory, how does this work so that we can drop a right contract, okay? So help me out. State your name for the record.
Yes, my name's Randy Capper. I work for Xcel Energy.
Okay, Mr. Capper, I made some assumptions there that this boiler always existed pre-Liberty Paper, or at least design-wise, because you need it for emergency sake. But was that the case?
Commissioner Tuma, you are correct. From the beginning of the design of Sherco, there was an aux boiler for just what you said, building heat and then startup. Steam required to start up a unit that is cold. That is correct, if there wasn't a unit running.
And then if a unit wasn't running, that gas boiler would provide heat, and now Liberty Paper comes along and is going to supply steam for them in the case that, for whatever reason, Sherco boilers go down. Was that the plan?
Commissioner Tuma, that is correct.
And when I read the agreement, here's where I want to be very careful, Ms. Steinhauser. When I read the agreement, that exists, okay? I had some concerns initially about this concept of seasonal dispatch. We required seasonal dispatch, and at that stage, all the boilers would just be down. I mean, in the shoulder seasons, they're just down, okay? And that gas generator is what is providing steam to Liberty Paper. And so that would be compared to pre-seasonal dispatch, that thing is running more often. That gas boiler going to need more O&M, going to need some more capital expenses. That would be my assumption. Is that correct?
Commissioner Tuma, I think that's fair, although Sherco Unit 3 typically is offered into the market year-round. Okay. So the seasonal idle was Sherco 1 and Sherco 2, which 2 is now retired. But typically, Sherco 3 is offered into the MISO market. So
it's fair to say it probably does supply more, it does operate a little bit more maybe than in pre-seasonal dispatch. And I think, and I'll be careful here, I think the contract, this is the way I read the contract, provides for that in a couple different ways, and I won't speak to them because they're all hidden behind trade secret, but it does require Liberty, which I guess in a sense the agreement between Liberty and this, whether it's a third party or this affiliated interest, your shareholders, which in effect is a third party here, okay, there was language in there that says they were going to pick up some of those costs for maintenance over certain levels. That's the way I read the agreement. Am I missing something?
Chair Stephen, Commissioner Tuma,
I'll let you say what it says because I don't want to violate the trade secret. So you can tell me how much you can tell me about that.
I don't have the language in front of me, and I didn't review it because it wasn't part of this specific record, but I can tell you that as part of the rate case, we were asked questions about revenues and investments made by the unaffiliated entity on behalf of Liberty Paper, and investments total about $16 million into the plant, paid for by shareholders because of that relationship.
And just and this concern about it operating more, I think was recognized in the affiliated agreement we agreed to in 2019, and recognized that some of those costs are going to be shared by this, non-ratepayer entity.
Yeah, costs required to serve that customer are paid for by the unregulated.
And the way I read it was in additional maintenance and O&M that would result because it needs to operate more often at a certain point. That was the way I read the contract. Right. I'm reading it right, Ms. Steinhauser?
Commissioner Tuma, I don't know of anything that would contradict that. That's consistent with my knowledge.
So as I look at this relationship, okay, before we had steam that was just going off into space, okay, and we're grabbing it now and using it for Liberty Paper to produce recycled cardboard. I'm worried about them going away. I don't know. This last week I've seen so many frickin' cardboard boxes in my front. My wife loves gift giving. She's a gift giver, okay, and I got so many boxes in my yard that is driving me nuts. I'm not too worried about them going out of business at this stage, but things could happen. They could move. They could find a better off-taker for steam. I don't know. They can uproot their equipment and go someplace else. I suppose that's possible. I'm not as worried about it. But before, this steam was just disappearing, dispensing into space. Okay?
I don't know that that's true because it's also used for heating and startup.
Well, it's heating and startup within the facility, but outside of that, whatever's leaving the facility is gone.
That is correct. It was blow-off steam. Yes, you're correct.
But we still need to heat the facility, and so now I want, we have this electrolyzer. It's just adding a little bit more gas on the outside to this facility. If you go to the next one, Mary, and this is where I wanted to get my brain around a little bit. So now let's fast forward to 2036. Okay, the reason I picked 2036, this is when you're going to have to negotiate a new contract with Liberty. Okay, and if everything goes as I think this commission anticipates it to go, okay, with regards to bigger things happening, okay, and yes, it's a joke, power stabilizer thingy, okay, on the left. I know what that is, but it's a different thing. The coal plant goes away, and the way I understand the plan is you're going to put a stabilizing unit in there, okay, to keep electricity going. It doesn't produce any electricity, but it's using a lot of the same infrastructure that's there. Smart, good, ratepayer use of that facility. But it's not generating steam, but it still needs heat, okay? And the heat from the coal plant is no longer there at this stage, okay? And so water's not going into the plant. Water's still going to that boiler, which will now have to be running more often for the plant, but not all the time. I would assume in the summertime in Minnesota, we wouldn't need to be supplying heat to that facility. It's only in the winter season for that facility. Is that your understanding when we get the stabilizer in there?
Yes, the stabilizer is synchronous condenser, yes. But you are correct. So we were 5 months out of the year that the aux boiler would produce steam for the heating of the building at Sherco for at least one synchronous condenser, correct?
I think in the new world, Liberty's going to still want power 24/7, 365 days a year. It'd be my guess. I don't know if they run all the time, but that gas boiler now will be operating more, okay? And so my challenge with all of this is what happens in that environment, okay? It's interesting that this affiliated interest agreement probably will be coming up at the same time these plants will be essentially shutting down. We don't know how soon and how fast. We don't have IRP saying that they'll be shut down by this stage. And so at some point, there will be at least a gap period where we don't know exactly what that relationship is, and ratepayer paid for assets, that boiler, okay, will be operating more, okay? That's my understanding of if everything goes as anticipated. Is that what you anticipate operationally?
Operationally, Commissioner Tuma, that is correct.
So there is some legitimate concern there, but if I read the agreement the way it sits right now, okay, the affiliate is going to have to maybe kick in a little bit for O&M and all those other things because of the way the contract is drafted now. Is that your understanding?
Commissioner Tuma, yes to that question. And then just like one more time to be super clear is that we have calculated that even if the steam customer goes away, those 5 months a year is enough for the learnings. Like we don't need to sign on another customer in order for the pilot to be effective.
And that was going to be my next line of questions, is that what you did say to us is that you have 5 months a year, it's going to be operating, it may be shut down for that period of time between the summer seasons because you don't need it, but you feel that you don't see any reason, if that steam customer leaves, that you need another steam customer for this learning from this pilot. It's going to continue to be there, and the likelihood that it's going to be picked up and moved to a Cargill facility to create anhydrous pneumonia is highly unlikely.
Setting aside the cargo example, that I don't know that but yes, it has a use in the facility itself for the synchronous condensers beyond the customer contract.
Again, this is a pilot, okay, and I can understand your concern. When I first got here, we had an issue with a battery down in western Minnesota that you guys put up, and we made you pay for some of the decommissioning because you didn't inform us exactly how costly it was going to be to decommission it, and shareholders got stuck with it. And so you have a shareholder risk here. Benson, turkey litter, great idea, I suppose, back before we did it. I was in the legislature. I remember it coming through, how wonderful we're going to burn turkey poop and we're going to create electricity, and then we now are paying to decommission that facility. And we did pay for that, but it was a lot of jumping around where we would get the money from and deal with that. And so I could see from a shareholder standpoint, if we were to do as the department and OAG recommend here and draft a whole new affiliated interest agreement, you're saying the likelihood of one getting done in time to install it. It wasn't whether, our order writer can get the order done in that amount of time. She started kind of spurking over there, saying, yeah, I think I can get it done by March. Okay. It's the concern that we go back and have to try to draft all this to try to deal with this gap season or deal with all the other issues that are there, that it may just not happen, one. And number two, my legitimate question here is, would you even do it if you would have to go down the avenue that we just heard this discussion where you're going to have to cover all these decommissioning costs? Would Xcel even do the project?
Chair Stephen, Commissioner Tuma, it's a great question. We would have to revisit whether or not it's feasible because that is not the cost and risk decision that was made with the NGIA order. That would be a departure from that. And these issues came up in the context of that hearing. We invited stakeholders to bring this into the rate case. There was discovery. We provided answers. Nothing that I'm aware of came from that in any testimony. We presented it here. There is no concrete evidence that we are mishandling the affiliate interest arrangement, despite some of the allegations going around. We provide annual reports that have not raised any issues. We are continuing to offer to provide those and enhance them to provide transparency here. We want the commission and stakeholders to have the information that they need to understand what we're doing. But rewriting the affiliate interest agreement here, excuse me, when the pilot is driven by the NGIA, not this customer, not the affiliate, I think it could risk the project.
Ms. Hinderly, you heard the discussion, and I really did go back and just focus on what the order said we're supposed to focus, and that's the contract. And it seems like you're wanting to rewrite the grant a little bit, which concerns me. I went back and looked at the contract, and there's been no discussion. I didn't see any discussion in your filings looking at the contract language. It seems to create some protections. I would agree there's a gap period when we start getting on to, the plant fully shutting down, and there's going to be 2 or 3 years where there's not going to be that coal steam out there, and this gas burner is going to probably be running more often, okay, which could create some concerns, but it also sounds like it has some operational usefulness for the synchronizer. And so I'm looking at that part of it and say there's some risk here, but not a whole lot when I look at that contract. There was language in there that said if there's more O&M on that gas burner, which is what the ratepayers we own, okay, they're going to pitch in for it. And she confirmed that, so I guess I can say that even though it was tucked behind the trade secret, and I can't talk about the numbers, I'm sure that's part of what it is, but there was language in the contract that said we will pay ratepayers, third-party interest, will pay more for O&M, and also there's a capital requirement in there to make sure that there's a capital division there for that burner, which is the big concern here.
Ms. Hinderly.
Chair Stephen, Commissioner Tuma, I think there's a real misunderstanding about what our ask is in this case. We are not asking Xcel to go renegotiate a contract with Liberty Paper. We are asking for the commission to really clarify that the 2019 order covers additional risks, additional potential costs. I'm not challenging that those might be minor. They likely won't happen. Likely, this scenario you've laid out is what will occur, and then we don't have any concern. I do have a concern with how much Xcel bristles at the suggestion that this what they argue is a very minute amount of risk should have to be borne by their shareholders. From our perspective, we're asking for a clarification. And I think before we got kind of thrown off by new decision options, that's what I intended to present to you here today, was we are asking for the commission to clarify that should Xcel need to decommission, recommission, transport, or interconnect the hydrogen electrolyzer in order to keep it in service, that its shareholders will bear those risks. That's our request. I don't think that requires a whole lot of work for Xcel. It doesn't require any action from their customer, and I don't think it, frankly, apologies to the order writer, I don't think it requires that much work from the order writer either.
Yeah, but again, when you look at the schematic here, it has nothing to do with the boiler. It has everything to do with the learning about putting something into a gas pipeline and getting to that burner. To me, the burner is what is the risks, not the electrolyzer. That's a pilot. That's a pilot that they don't want to be stuck with in the end and not, say, we find out that hydrogen, and it's not, I'm getting a little nervous about hydrogen, whether it's getting into the turkey litter level, because a lot of people are backing out of the hydrogen hubs and stuff like that. So I get the concern. I have concern whether we're going to learn something from this, or we're going to be saddled with another turkey litter burner. Okay. That's a legitimate concern, but enough here, I believe that hydrogen has a promise that we need to learn something from it, but I don't know how that gets into shareholders paying for something because they have an affiliated interest beyond this boiler. I mean, you look at the schematic, the boiler is what the problem is, and it sends steam down to these pipes, and then it's the affiliated interest going out. So what's behind it seems to have no relation, particularly when we understand that this is very important. Synchronizer needs to have heat, and they're going to learn still and keep that likely there. That's their word. Now, we don't know that because this is a learning. This is a pilot. Okay, this is what we're going to learn from this. I mean, I'd be kind of curious when you get to it, whether you might even consider putting in a traditional combined and heat, electric combined heat CT turbine after that boiler, and so that it, that might be a learning from that we could have and make it more of a traditional, like right now, the heat we're getting right now here in this building. So, I mean, there's a lot of things that we could learn that we don't know what they're going to reconfigure when we get to this in, 5 years. It could be a whole different, but I don't see the risk in the agreement. That was what we're supposed to be focusing on today, is this agreement. And I don't think it changes the agreement any, what is upstream from that boiler. Because that's what we're talking about, what's upstream from the boiler.
Chair Sieben, Commissioner Tuma, I don't think I'm going to go back and forth with you anymore on this. I would encourage the commission to at least clarify that small business and residential customers, in the case of, future, that they won't bear those costs.
Our order says that, and I think I like your decision option,
again.
Madam Chair. I
Yeah,
thought your
we can say
decision
it
option
again.
says, before we make any major decisions, we're going to sit down and have this conversation, because there's a lot of things we won't know about until you start building the facility there, and there's going to be a lot of things happening during that same time at the Sherco plants, happening simultaneously. That's why I'd hate to wait for one to inform the other. Let's just dive into it and see where we get, and let's hope it's better than turkey litter, I guess is what I'm thinking.
Commissioner Tuma, that was really helpful. I think in the case of the CenterPoint electrolyzer that's being constructed in Mankato now, did Dr. Lieb or Ms. Hinderly, do you recall if you asked for the potential stranded asset costs to be borne by shareholders in that case? Are you generally is this a general concern about hydrogen here, or this is more just specifically about the previously approved AIA between the unaffiliate and Xcel Gas here?
Chair Sieben, our concern here is really the potential, because CenterPoint's, my understanding of CenterPoint's hydrogen facility is that it's going to be directly connected to their gas distribution system. That the likelihood of everyone going off the gas distribution system and making that a stranded asset within the life of the electrolyzer seems to be a much smaller risk than the potential of a single industrial customer in a fairly exposed industry going offline.
Okay.
So that's why
I
we
get
were
that.
concerned about this pilot.
And I get that. I think my decision option, new 12, then also by their notification and what we outline will capture that. So I'm comfortable moving ahead if you are, Commissioner Tuma and
One question
Commissioner
along the lines where
Hahn.
we're going. Would you have a problem at the end of the pilot or in 5 years to just give us kind of a operational update of where you're going? I mean, I think we'll know a little bit more about.
Isn't that already happening?
I think so, but I
That
guess
is
I want to
happening.
know a little bit specifically about how Sherco plant relates. So if we do go away from coal, okay, and, I'm assuming Liberty is going to still be there, but I mean, assuming Liberty is going to be there, just to have some discussion about how you might be considering reconfiguring, because that's going to be closer to when you have to start renegotiating the Liberty contract. And so it'd be nice, at least for the commission, to hear your thinking at that stage of how that relationship is going to work post the coal burners going away.
And Commissioner Tuma, are you saying you want those earnings in or learnings in the NGA pilot when they re-up for their application in 5 years?
Yes, that's what
Yeah,
I'm
I think it is already, but Ms. Steinhauser, do we need more?
Chair Sieben, Commissioner Tuma, candidly, I can't remember all of the all of the reporting requirements. There's a lot, but we will make sure to include the context around what's happening in the space where this is located, so that you know kind of how that's moving.
Yeah, I mean, I'm comfortable with that. I did drop a decision option, but I don't know if you be okay with it. Do you have it where we can display it or hand it out? Because I think it's important for
More
us
learning is good.
to continue to have this conversation and know that you're thinking about where it's going, because that makes me more comfortable with the direction that we go. And so, and be honest with you, we're struggling trying to get the right wording as of this morning. So if it's problematic, let me know. And I would agree with you, Madam Chair. I think the original learnings thing would include this, but I'm just making sure we're really specific
I'm just
about it.
clarifying, do you want this separately in this item, or you want this to be reported in their application for the next 5-year NGA? Because, or maybe it should be both.
I just asked the staff to say that when we get done with this electrolyzer pilot, which I thought was 5 years, that we would ask them to give us some learning in this docket, and also in whatever the next affiliated interest docket file that's there too, not knowing whether any of us are going to be around when that happens. So we want to make sure that we're connecting the two dots.
Yeah,
That's what I was
staff
trying
can
to accomplish.
staff can file it wherever they need to, right? Or Ms. Nikitas, do you have an idea about this?
Yeah, and one strange part of NGA is that according to the statute, the company and the way that the annual reports work, it does look like the company will have to do a proposal for their next plan before the final report is due. And so I think in some of the language we had workshopped, we had said this could go in the final report, but we could also amend it to say if you all were planning to propose a continuation of this pilot in your next NGA plan, that this could also be part of that application. Because we did, the commission did order that if it is going to be in future NGA plans, it needs to be incorporated as part of the budget.
Yeah, and I didn't know what the timing. My whole goal was once the coal burners go down, I want to know what you're thinking is what I want. But go ahead.
Commissioner Tuma, that all makes sense. We can do it. I think if we're proposing to extend it, it should include that information anyways, right? In terms of how it's going to be used and where it's at. And then also in the final report, that would make sense. So we're okay with all this.
Thank you, Madam Chair.
That sounds good. And any objection or concerns with the TUMA New 13 from the department or the OAG?
Chair Sieben, Commissioner Tuma, I think we would offer an edit to TUMA 13, specifically that cogen opportunities should be explored as fully regulated businesses if there's steam coming off a regulated asset and going to a third-party customer, and that we should be looking at how those steam revenues could be used to pay down the cost of innovative technologies like hydrogen electrolyzers.
You'll be free to bring that up, I'm sure, under the way this is. Any possible cogeneration opportunities, if Excel reports on it, then in reply or whenever, you'll be able to bring up those concerns. So I think that's included
We're
in
happy
it.
to bring it up. It's usually easier to get the company to propose those types of proposals if they're being directed to do it initially.
Ms. Hinderly?
Very minor, Chair Sieben. I'm just not clear what year of the annual affiliated interest agreement the compliance filing would be made in. Would it just be in the same year as the final NGIA plan?
Yeah, whatever that my intent was, is that whatever when the NGI plan is up and this is filed, file it also in your next annual report is the idea.
Any additional thoughts, Commissioner Hum? Then if we move to my new 13, my new 12, decision option 6, and decision option 11, and then decision option 1 from docket 23518, that's approving their compliance filing and allowing Excel to proceed with the pilot. Does that make sense, staff, for an overall motion for both dockets?
Please reread the decision options, please.
So it would be, and I'm going out of order here, apologies. So decision option 1 from docket 23518 to approve their compliance filing and ask Excel to proceed or allow Excel to proceed with the pilot. Decision option 6, which is consistent, which is like belt and suspenders. Again, this is recovery for the pilot will be from, not from residential and small business customers. Decision option 11, ask them again to include fuel-related cost information in future annual filings in this docket. My new 12, and to my new 13.
Sense to me, but
Yes, that's clear.
Okay, thanks. Any discussion of the motion from commissioners? Then we'll proceed to vote. Commissioner Hom,
Yes.
Commissioner Tuma.
yes.
I also vote yes. The motion passes 3-0. Thank you, everyone, for your patience with this. And we'll take a recess now until 12:30. Or do we need a little longer, commissioners?
I'm gonna run and grab lunch, but
How about 12:35? We'll come back to take up our final dockets. So commission stands in recess.
go get this thing stuck.
The commission will come back from its recess, and apologies for starting a little bit later than I thought, but we'll now take up agenda item number 4. Ms. Pham, please introduce the item when you're ready.
Thank you, Chair Sieben. Good afternoon, Commissioners. Item number 4 today is docket number G-002/MR/25-403 in the matter of the application of Xcel Energy's petition for approval of gas state energy policy rider recovery with true-up mechanism. Excuse me. The questions before the Commission today are, should the Commission approve Xcel's proposed SEP rider recovery to establish baseline for $46.3 million effective January 1st, 2026, subject to true-up to actual 2026 expenses? Staff also note that the company adjusted this initial baseline amount in its subsequent filing. And question number 2, should the Commission approve Xcel proposed capital true-up for 2026 through the existing SEP rider? Should the Commission approve Xcel proposed property tax true-up for 2026 through the existing SEP rider? Should the Commission approve Xcel proposed labor cost recovery for 2026 through the existing SEP rider? And should the Commission approve Xcel proposed damage prevention recovery for 2026 through the existing SEP rider? Should the Commission approve Xcel proposed manufactured gas plant costs for 2026 through the existing SEP rider? And last question, should the Commission approve Xcel request to leave its base rates unchanged in 2026 and to withdraw its application for a general rate increase in docket number G002/GI-25-356? Staff and parties are available for questions.
Thank you, Ms. Pham. If the parties want to come forward for appearances, we'll begin with questions from commissioners. Good afternoon, Mr. Pranis. Starting on my right, please state your name and the organization you're representing.
Thank you, Chair Sieben. Commissioners, Kevin Pranis on behalf of Liona, Minnesota, and North Dakota.
Good afternoon, Chair Sieben and Commissioners. Elizabeth Brahma with the Taft Law Firm on behalf of Xcel Energy.
Good afternoon, Madam Chair, Commissioners. Ian Dobson with Xcel Energy.
Good afternoon, Chair Sieben. Richard Dornfeld, Assistant Attorney General, appearing today on behalf of the Minnesota Department of Commerce. I'm joined today by Nancy Campbell and Ashley Eufus from the department.
Good afternoon, Chair Sieben and Commissioners. Brian Edstrom with the Citizens Utility Board of Minnesota.
Good afternoon, Chair Sieben and Commissioners. Joey Cherney from the Office of the Attorney General, Residential Utilities Division.
Great, thank you. We'll begin with Commissioner questions. Commissioner Tuma, did you want to begin with questions?
Yeah, I could start. I was reading the record, Mr. Dornfield. I was just curious, how much outreach did you have as far as whether you would be agreeable to a stay out on this? Have you been, how soon and when? I mean, I know there's no settlement, so I can ask you these questions. So was there outreach to you as trying to figure out whether you could agree to this?
Chair Sieben, Commissioner Tuma, I believe there was some outreach from the company to the department. There might have been some discussions. I can't say that I was party to all of it. I can say I was party to any and all conversations that might have occurred. I think ultimately the department's concerns are laid out best in its comments.
And the CUB, was there outreach as far as, I mean, that's the tenor of the discussion as far from the parties that are opposing this was that a lot of this was coming in late. You asked for additional information. It didn't seem like to me that it was a lot of preparation as far as coming to here with trying to find a settlement.
Chair Sieben, Commissioner Tuma, no, we did not hear from the company about this proposal.
Mr. Cherney.
Chair Sieben, Commissioner Tuma, there was no affirmative outreach. We sort of heard through the grapevine that this might be an idea, and we asked for more information and didn't really get it.
Mr. Dobson, this was my sense just reading the filings, is that this kind of dropped and not really a lot of outreach beforehand to look for settlements. To me, stay-outs are a kind of a very unusual beast that require at least some input, and probably bringing along some of the stakeholders along in filing this. Trying to recall some of our past stay-outs that we've done with you. I thought there was a lot of outreach on the electric side, so I don't know if there's a different philosophy over on the gas side of XL, or is my reading of the record incorrect?
Madam Chair, Commissioner Tuma, I don't think your reading of the record is incorrect, and I don't don't disagree entirely with the comments that were made. There was some outreach, but it wasn't from what I recall from our previous stay-outs, it wasn't as robust as it has been in the past. I think the main reason for that isn't at all a shift in philosophy or a difference between our electric and gas case. I think it was simply that we were, in all honesty, putting this together. I mean, we were thinking through this along with the gas case. We probably didn't have as much advance work on it as we would have we would have liked. And so we were I think we had contacted the department, told them generally that this was something we were thinking about. I did have, some conversations with the OAG. I agree. I do think it was initiated by them in a conversation about something else, but to really go through it, sort of in detail, we didn't have the ability to do that.
So to contextualize this in my brain, this is how I have it. I'll say it to you, and you can disagree if I'm wrong. Kind of crystallized in my mind when I read one of the comments saying, the numbers changed between the initial filing and the additional information. And so I'm seeing that this is coming at us from the gas company a little quicker, maybe not fully baked, maybe like the electric stay-outs were back in the good old pandemic years. And so not to say you didn't want to consider settlement, but as it sits right now, there's a lot of ingredients that are still being added to the mix, and it probably wasn't as fully baked as maybe our past electric rate cases were.
Yeah, I think I don't know that I get why you're looking at it that way. I think a little different. There was an error. I mean, there was an error in the property taxes. We grabbed the wrong number, and that was a change. I think the other difference that I would point to, or the reason I have a little different view on it is, we've put forward a conceptual stay out. The numbers that we've put in the stay out match our rate case, except for instances where they would need to be different. So those have been built up, and really what the stay out is getting you is an initial revenue recovery. We would implement that through the SEP rider, and then we get to the end of the year, we're going to do a true up to actuals. So in our view, there's going to be a thorough review of all of this. It's just, we're going to do it at the end when we look at the actuals rather than throughout the course of the case. There's often adjustments made during a rate case as well. I don't see it differently in that way.
I have a couple other questions.
It was interesting, Commissioner Tuma. I hadn't thought of it in the context of previous stay-outs, but my recollection, usually stay-outs from the past electric cases were done in multi-year rate plan cases. And so that kind of gave a little bit different level of flexibility for the parties to, at least, if I'm not mistaken, is that right? Mr. Dobson, where past stay-outs were done like in year 2 or 3 of MYRPs? And is that a material difference here?
Madam Chair, my recollection is that they were done at the conclusion of an MYRP, so we would be coming in with either an MYRP or a stay out. So in that way, I see it as similar. I realize that there's a difference here in that, just the vehicle of using the SEP rider does make it different than I think in the previous ones. They've been true ups to various components.
And when they were done at the tail end of an MYRP or at the end of a rate case, then the testimony is already filed and part of the rate case for the most part, right? I guess though sometimes it did come in at the end, new information, and then the commission was offered like take the stay out or not. But the discrepancy I see here that is hard for me to get to yes on your proposed stay out is that it's through the SEP rider, and that I just don't think like legally we have the same broad jurisdictional ability to be like, oh yeah, this looks good, this would result in just and reasonable rates, when it's pretty questionable whether some of these costs could run through that rider.
Sure. To address that, I think I wish we would have. I think in the last sort of few days, as I was preparing for this hearing, I think there's sort of there's a different way we could have sort of explained that piece of our argument. I think the way that we have seen this stay out is, I think ultimately under it's not a statutory rider. I understand that, and that's not how we're envisioning this. When we look at sort of the commission's rate-making authority and you look at the 216B16, that's really a process designed to get you to just and reasonable rates that you guys conclude under 216B03. So that's, to us, really the core question, and will this stay out with true-ups at the end get you to a point that you can be comfortable that these are just and reasonable rates? With respect to process, the part that I wish we would have maybe focused more on is when you look at 216B16, what it allows you to do. We propose a rate increase. We have to propose it 60 days before. We have to provide all the information. You can accept that. The statute says you may accept that rate, that increase, or you may suspend it. If you suspend it, which the commission has always done, then we go into the contested case, interim rates, because you're suspending our proposed rate. The way we've looked at this is we've proposed a final rates of $63.4 million through our rate case. We've also proposed a stay out of about 45. So what we're asking you to do is not suspend implementation of this stay out, which we would collect through SEP. That's just the vehicle, on the condition that we withdraw the full rate increase. It's different, it's unique, but I think the statute gets there. Of course, if you can conclude, it's your call, whether it will result in a just and reasonable outcome under 216B03.
Mm-hmm.
That's how we see it.
That's how it's a little tricky then not to have the support of the other parties for this then too, though. That will be in the rate case if we deny this. But Mr. Prentice, why is LIUNA in this docket but not in the rate case?
Chair Sieben, commissioners, it's a question of bandwidth and how many things we can pay attention to. And so I think we became aware of the sort of stay out proposal. I think we're likely interested in being involved if there's a rate case. It's frankly just, I think, easier on a lot of folks. So, we see that if we can get to just and reasonable outcomes with, sort of like less effort and difficulty, that's always a nice thing to do. And so I think that was our general view, is that this looked like a fair deal, especially for residential customers, I think, who arguably need it the most, and allows us to focus on other things. But if the commission, orders this into a rate case, I expect that we would join the rate case likely.
Mm-hmm. Okay. That's helpful. Commissioner Tuma, you had other questions?
I guess I'd just be curious. I mean, you heard it seemed like the argument I was getting from my three lawyers up here, I'm Blanc of the advocates, was that we are going to be violating the statute. You heard the argument. I mean, there's something attractive about the numbers, okay? So first, give me the legal argument, and then I want to ask kind of more of a policy argument after. Give me the legal argument why you would be concerned about us using the approach, even as described by Mr. Dobson. We're accepting a rate as opposed to opening up a new rider.
Chair Sieben, Commissioner Tuma, I think Mr. Dobson kind of said the quiet part out loud, is that it's not a statutory rider. Of course, the commission has its general authority and its rate-making authority, but the legislature has determined that the commission needed specific authority for other riders. And as a canon of construction, when the legislature expresses one thing in statute, it implies that anything that's not expressed isn't permitted. So that the legislature created authority for other riders, but not this one, suggests that the commission doesn't have authority to put anything it wants through the SEP rider, which is a catch-all for other statutorily created cost adjustment processes. So I think that's a statutory argument. I think the other kind of broad concern is we're talking about $46 million after 2 weeks of notice and comment. I mean, the property tax error is a good example of the kinds of things that the department and other parties routinely find in rate cases. And so I think the department has real concerns about blessing maybe that's looks attractive compared to the proposed rate case amount, but we don't know that that's going to be what this commission would ultimately approve should this go to a contested or through contested case. And so I think the department has concerns about what might we find if we look under the under the hood here and really evaluate this rate case. And we also think that it sets a dangerous precedent. If you can put $46 million to the rider this time, what's to stop a utility for proposing $150 million next time? And so for all of those reasons, the department just couldn't get comfortable with this proposal.
Cub, what's your argument? First, the legal argument, then just the policy. Why shouldn't we do the mini rate case, I guess we want to call it that, as opposed to the rider?
Thank you, Chair Sieben and Commissioner Tuma. The legal, I certainly agree with what Mr. Dornfeld said, and yeah, I think the statute that sets out the procedure for rate cases does give the Commission authority to approve rates that you determine are just and reasonable, but typically the process that you use for determining that they're just and reasonable is a rate case, and the process of having parties like those of us here and others kick the tires and go through and challenge things that might warrant challenging, and that process is what it gives you the record and the information that you as decision makers then utilize to determine whether rates are just and reasonable. So I think though there might be a back-end true-up and process for doing that, I think it would be a less robust process. There wouldn't be, I imagine, the same opportunity for witnesses to weigh in, for as much discovery, for an evidentiary hearing, et cetera, et cetera. And a further legal argument is if the Commission is concerned about the immediate impact of a higher rate increase beginning in January, you do have a mechanism for addressing that via the exigent circumstances language in the interim rate statute. I know that not everyone likes that statute, but as a matter of law, the legislature provided you that authority and that discretion, and that authority has been upheld by the state Supreme Court. So if you're looking at where the law and the legislature gives you authority, I think that's the clearer route. And then just as a matter of policy, CUB has historically not been crazy about overuse of riders, just because we think it can render rates in general less transparent, and kind of dividing costs up between base rates and riders can make it a little more complex to see the full picture, and for both advocates and ratepayers to understand what they're paying for and why. So That's why we oppose it.
That was kind of one of the arguments I thought was convincing, is that the mini rate case, even if you take it, the transparency of it is very difficult at this stage because we don't know a lot of information at this stage. Mr. Cherney, anything to add to the legal argument or the policy argument?
Chair Sieben, Commissioner Tuma, my colleagues have obviously they've said a lot that we agree with. The only thing that I would add is that even under Excel's analysis using point 16, if there are contested issues of material fact, which there are, there should be a contested case process. And then the other thing that I'd just point out is that in Excel's rate case testimony, witness Liberkowski says that the costs in the rate case, which are essentially the same costs that are in the stay-out proposal, she says that they are the drivers of the costs are focused on reliability and connecting customers, plus other costs that are not authorized by statute to be included in the GUIC rider. And the quote is, "A base rate increase is the most appropriate avenue to recover the costs of these investments." So Excel, admits that in its own testimony.
And I think that's what Mr. Dobson's saying is, we view this now as more just to prove our, rate increase, and we'll come back and deal with it later. So that's all the questions I have, Madam Chair.
Yeah, I don't have a lot of other questions. Commissioner Hom, did you?
Thank you, Chair Sieben. I just have one comment to make. To me, this is a backdoor formula rate. And I can consider personally, if company bring the offer along with reducing your return on equity by 200 basis points, yes, then I can think about it. But I think ratepayers should have a significant benefit if you can give a lot of this kind of rider in addition to above and beyond what statute allow us to approve. So that's why I am very skeptical about this proposal. I understand your intent because you are trying to help in different way to the ratepayers who may have a significant impact from the rate case. But I think we have to deal with it.
I'm ready for motion, Madam Chair, if you are.
Go ahead, Commissioner Tuma.
Moved decision option 2, and I think that's all I really need. I'm looking over at staff, and they're nodding their heads, so I wasn't convinced, and I appreciated the conversation we had, but I think we just got to rip the bandage off and get her done.
Any other discussion? We'll proceed to vote on decision option 2. Commissioner Hom?
Yes.
Commissioner Tuma?
Yes.
I also vote yes. The motion passes 3-0. Okay, then we'll take up the rate case when we get parties shifted around here and staff. Ms. Pham, please introduce item 5.
Yeah, thank you, Chair Stephen and Commissioners. Item number 5 today is docket number G002/GR-25-356 in the matter of the application of Xcel Energy for authority to increase rates for natural gas service in Minnesota. The questions before the Commission today are: should this filing be accepted? If so, should the proposed rates be suspended? This matter referred to the Court of Administrative Hearings and interim rates set as requested by the company. Staff also has a few edits of the briefing papers. The company just notified staff that there was an error at the end of page 8 on briefing paper, where it has a list of changes. On this list, the third item, where it said distribution increased by 31.5%, that was an error. It's a duplicate because it was listed above that gas distribution increased by 30.2%. So it was thinking it may be a copies and paste number, and so that item should be removed from this list.
So just maybe just cross out
Just cross out from this.
distribution increase by 31.5.
And because of this change, it should carry on to the decision option 10C. Same item should be crossed out.
10C, okay, got it.
10C on page 34. And then there are a couple few edits that just a minor typo. All of them on page 34. The first one is at the beginning of page 34. The statement said if the commission adopts DO3, where it should be updated to if the commission adopts DO4. Second edit on this same page 34 is in the decision option number 8, where the date said June 31st, 2026, should be corrected to June 30th, 2026. And the last edit is immediately follow the decision option 8, where the statement said if the commission adopts DO4, it should be updated to if the commission adopts DO5. With these changes, staff has no additional edits. Staff and parties are available for questions, and parties have been informed that they will have opening comments. Thank you.
Thank you, Ms. Pham. We'll begin with the company for a few minutes of opening comments.
Sure. Thank you, Madam Chair, Commissioners. Start by saying that, this rate case obviously reflects 2 years of increased costs since the last time that our customers have seen their base rates increase for our gas business. Obviously, we'll get into the specific costs and any disputes about those costs when we go through the rate case, but obviously the significant drivers that we've pointed out are increased costs to improve our fire suppression system at some of our peaker plants, some other capital-related things, a new control room at one of our gas plants, some reliability upgrades, and some O&M pressure over the last 2 years. As your staff laid out in briefing papers, our full request would result in an average bill increase of 8.2% over those 2 years, while the statutory formula to set interim rates would increase rates by 6.8% over those 2 years. I say that obviously in full recognition that obviously our customers would probably prefer not having any rate case at all, but we think that these are needed increases at this time. So getting into today's decision, we appreciate that all of the parties that have commented in this agree that our filing is complete, meaning that they agree that we've put forward the information that we needed to start this proceeding, but obviously they haven't reviewed it critically and they don't take a position on the merits. And that means that in our view, the only decision for you right in this proceeding is interim rates. So I'll make a couple of comments on that. First, I think the arguments made by the department and the Citizens Utilities Boards are essentially the same as the arguments that were made in the Otter Tail case that the Commission decided last week. And I think the reason to deny an exigent circumstances finding here is similar to that. Obviously the government shutdown that they referred to has ended, and I think some of the other components of those arguments are basically the same. With respect to the OAG's arguments about looking to the amount we requested in our stay out, I think that really oversimplifies the proposal that we made in the stay out, which obviously the Commission just decided not to go with. But the way I see it is that the OAG has sort of tried to suggest that we've somehow agreed to a lower interim rate. The cases that they've cited are situations where a utility agreed to a lower interim rate, and because the utility agreed to that, the commission found exigent circumstances. And that's not what's happened here. We factually, we haven't done that, and the reason is the stay out we proposed is fundamentally different than interim rates. Under the stay out, there was a substantial, a real benefit to the company, meaning that we would have certainty going forward on the cost categories. We wouldn't be talking about budgets. We wouldn't be talking about sort of that look forward process that you do in a rate case. We would be going to the end, and obviously we would have to spend money prudently, and that would be reviewed, but it would be a different look that you can't really apply over to interim rates. And I think stemming off of that is an important difference in that what we had proposed in the stay out was a symmetrical true up, which you cannot have in interim rates. If we had spent more and the commission determined that that was prudent, we would be able to recover that more under our stay out. Under interim rates, those are capped. And so I think those are differences that mean I don't think you can just take the number that we proposed as a stay out, bring it over to interim rates and drop it in and suggest that we've agreed to that. We didn't, and so we just factually don't think that's a reason to find exigent circumstances. So we think that obviously we understand that all of these costs are going to be reviewed throughout the process of the rate case. To the extent that the commission, like always, finds that our rates, to the extent that the commission finds that our rates are lower than interim, as is required by statute, we always have to give a refund, and we would do that. So we would ask that the commission set our interim rates according to the statutory formula, find our filing complete, and refer the matter to the OAH for a contested case.
Thank you, Mr. Dobson. Next, how about Cub?
Thank you, Chair Sieben. Brian Edstrom here on behalf of the Citizens Utility Board. And I agree with Mr. Dobson that I think the primary issue for you here today is considering the exigent circumstances that we and others have made. So I'll just make a few comments on that. And I know you decided that last week in the Otter Tail rate case, though I know Chair Sieben and Commissioner Hom that you weren't at that hearing, so I'll kind of repeat some of the comments I made there. Starting with, I just want to say that I know that it may frustrate the commission and utilities to just see the number of times that exigent circumstances have been argued in recent rate cases. We're aware of that. We appreciate that. But I think that really reflects the unusual circumstances that have been going on recently. Obviously, I think we all agree that the pandemic was a highly unusual circumstance that warranted those findings during rate cases filed in that period. But I think if that pandemic had not happened, some of the events more recently would maybe appear more surprising and more shocking. The shutdown, which I recognize now has ended, but firing of all LIHEAP workers, disruption to SNAP benefits, rising healthcare premiums that look like they're about to hit Minnesotans beginning next month. And affordability is in the news every day. Energy prices are often a part of that discussion, and it just continues to be a concern that we have for ratepayers. So we believe that the evidence that we've provided and the department has provided, and the arguments that the OAG has added that does make this a bit distinguishable from the Otter Tail case, would give the commission enough evidence should they decide to find exigent circumstances warrant lowering interim rates. But of course, we respect and honor your authority in making that decision based on your review of the facts. So I'm happy to walk through my decision options, or otherwise I can stop there.
We can come back to decision options later if there's discrepancy or questions. The Office of the Attorney General, please.
Thank you, Chair Sieben. Good afternoon. My name is Wendy Raymond with the Minnesota Office of the Attorney General Residential Utilities Division. The Commission should limit interim rates to no more than $46.3 million, the increase provided in Excel's stay-out petition. The stay-out petition creates an alternate basis for the Commission to modify Xcel's interim rates. As noted in our comments, the Commission has found exigent circumstances before, when a utility has acknowledged that it did not need the full amount provided by the interim rate formula for its operations. The Commission found exigent circumstances for Dakota Electric at least twice, and an almost identical case from CenterPoint when CenterPoint filed a stay-out. While in Dakota, the utility admitted a lower interim increase was sufficient, but for CenterPoint, the utility filed a stay-out petition which was denied, as the Commission has just done so here. The Commission also regularly finds exigent circumstances to allow the utility to not collect from large industrial customers, and did so as recently as Merck's 2022 rate case. As the Commission has found, permitting an interim rate increase beyond the utility's operational needs goes against the public interest. This is different from last week's situation in Otter Tail because Xcel has demonstrated that it can ensure its, quote, adequate, efficient, and reasonable service with a $46.3 million increase. Also distinguishing this case is that Xcel just implemented final rates from its 2023 settlement in March of this year. In contrast, Otter Tail was out for the past 5 years. The Commission should use its authority and discretion to modify interim rates. I note that the OAG continues to agree with the Department and CUB regarding hardships and economic uncertainty facing Minnesotans, especially residential customers, and believes the Commission should have or would have record support for either option presented by these parties. I can go through our preferred decision options or wait. I do note that for decision option 22, if the Commission chooses to allow Xcel to not increase rates for transportation customers, the Commission should amend this decision option to include a finding of exigent circumstances to allow Xcel to avoid increasing rates for transportation customers. Xcel is deviating from the statutory formula. This amendment could be accomplished by adding, quote, finding exigent circumstances and to the beginning of that decision option. Thank you. I'm available for questions. 22.
Good afternoon, Chair Sieben, Commissioners. Richard Dornfeld, Assistant Attorney General, appearing today on behalf of the Minnesota Department of Commerce. I'm joined by Nancy Campbell and I believe Justin Taylor and maybe also Mary Beth Kerwald online. I'd like to focus my comments here this afternoon on the exigent circumstance issue that we've been talking about. As the Commission knows, that unless the Commission finds exigent circumstances, then interim rates get calculated based on the formula found in 216B16 subdivision 3B. Exigent circumstances isn't defined by statute. When a term isn't defined by statute, generally we want to apply the plain meaning. So cracked open a dictionary and we're talking about an incident or occurrence requiring immediate action or making urgent demands. And since 2008, the Commission has found exigent circumstances at least 20 times by my count. And what I think is striking about these different circumstances is they're not uniform. The particulars deviate quite a bit. The Commission has found exigent circumstances in particularly urgent or dire situations where a utility filed rate cases in rapid succession and during recessions, the pandemic, and periods of high inflation. But the Commission has also found exigent circumstances exist in, I think, considerably less urgent situations. The Commission found exigent circumstances justified a utility including the costs of a new incentive comp program at interim rates, even though it was not of the same kind of nature of current expenses. That was in 2007. And as Ms. Raymond just noted, the Commission has also found exigent circumstances repeatedly to allow gas companies to avoid increasing rates for competitive customers, customers who could leave the system. And in one case, the Commission allowed, made a finding of exigent circumstances for administrative convenience to match up interim rates with the test year. Obviously, this is subjective, but at least in our view, the sort of second category is kind of far to the other extreme on this continuum of what is exigent. And in the department's view, the circumstances facing Excel's residential customers today are decidedly closer to the first category I talked about, the rapidly successively filed rate cases, high inflation, economic uncertainty that present hardship. And although the federal shutdown might be over, many low-income customers are still dealing with delayed or foregone food and energy assistance that make it hard for them to catch up on their bills or meet their living expenses. And we continue to see rising healthcare costs and inflation caused by federal policy decisions that are presenting a real hardship for residential customers. And there continues to be a weakening job market, as the Federal Reserve in its decision yesterday. And so given these confluence of circumstances, the department recommends that the commission exercise its discretion to find exigent circumstances and reduce residential rates by 50%. Thank you.
Okay, thank you. And Mr. Prentice, you aren't a formal party here, but you were in the last case. If you want to say something, I assume you can just file a motion to intervene once this gets to the CAH. But I don't know. I just wanted to give you an opportunity since you weren't listed as a party, but spoke in the previous docket.
Thank you, Chair Sieben and Commissioners. Yes, it would be our intention to file as an intervener in the rate case. I think, again, we're obviously torn between members, the need to maintain a system that our members work on and the rates that our members pay here. I don't think nobody likes rate increases. We don't. Exigent circumstances seems like a high bar that is appropriate for sort of extraordinary circumstances. There's unfortunately nothing extraordinary about people struggling to pay their bills, and because changes to interim rates don't actually end up solving any problem, they don't mean that the costs don't have to get paid. They just sort of like move the timing around. We don't see, it seems like those tools should be used for actual exigent circumstances, and we don't see that today.
Okay, thank you. Commissioners, we'll move to questions now. Who would like to begin? Commissioner Hom.
Thank you, Chair Sieben. So I'll start with the easier one. So decision option 27. COB asked Excel to do email notifications. Is it okay with the company?
Madam Chair, Commissioner Hom, if yes, we're willing, we would do that if that's what the commission wants.
Okay. So next one is
just on that line. I assume you'd be okay if we add that to the 25 things that must be approved by the executive secretary. So just bill inserts, comma, email notices.
Yeah, that's fine.
Okay. Next one is decision option 12 and 13. There's a 1 day difference.
Sure, Madam Chair. I mean, I think if it doesn't, it's we're kind of indifferent. We would implement on January 1 no matter what. The cleaner way is probably 13 in my mind.
Okay, thank you. Okay, now we have to go into a little more difficult ones, exigent circumstance. So yeah, I wasn't here last week, but also other commissioner made a decision on the Aratel case that we didn't find this exigent circumstance. So company first, I think, do you see any change in economic circumstance or any other thing between last week and this week?
Madam Chair, Commissioner Hom, recognizing that I'm certainly not an economist, I I'm sure there's little changes happening all the time. I am not aware of anything significant that would get you to exigent circumstances.
Thank you. And the department, I heard that you mentioned about Federal Reserve Bank statement from yesterday. So I recognize it. That's the one thing. But do you know anything else that you can distinguish between last week and this week?
Chair Sieben, Commissioner Hom, the department's position is that the economic and sort of societal hardships that residential customers are facing, the ones that the department described in its comments filed a few weeks ago, existed last week, they exist today, and that the commission should exercise its judgment or its discretion to authorize exigent circumstances. I believe that's the same position the department took in Otter Tail as well.
Okay, thank you. In that case, do you perceive, so it'll be a very unfair question to you, do you think, is it going to be better in future years? I think a lot of people are expecting this affordability issue is a huge problem, it's an ongoing problem, and indefinite future. Do you see there is any chance that we can get better?
Chair Sieben, Commissioner Hom, I don't have a crystal ball or a DeLorean, so I'm not going to speculate about what the future might hold. But if we look to the past, I'd note that the department and other parties have not always recommended the commission find exigent circumstances, and utilities weren't always filing double-digit percentage increase rate cases every other year. This is an unusual set of circumstances that we're all facing, and they require us to kind of rise to the moment.
So set aside the merit of the double-digit increase. I think you will do the math at the end of the rate case. But given this unusual pattern of ongoing problem, don't you think we need a more permanent solution rather than we keep arguing this on every rate case?
Chair Sieben, Commissioner Hom, the department, like the commission, is a creature of statute. We have the authority that the legislature has granted to us. And so we look to the tools that are available in statute. And the state legislature has granted the commission authority to find exigent circumstances to reduce interim rates. And while that tool is available, I think the department will always look at that to see if it's appropriate given the facts and circumstances presented by that case. And we'll bring those recommendations to the commission when it thinks is appropriate.
Yeah, thank you. So what I meant, the permanent solution, department has more tool and ability. Can department pursue more permanent solution through statutory changes rather than doing it in the rate case every time? For foreseeable future, we may see this circumstance every time when company file rate case.
Chair Sieben, Commissioner Hom, I'm certainly happy to take that feedback back to the department. I can't commit the commission or the department to seeking a legislative change, but certainly I'd be happy to share your feedback with the department.
Okay, thank you. So I'll go to the CUB. Same question.
Thank you, Commissioner Hom, and I think those are fair questions. I do think maybe considering legislation around that statute would be beneficial. I know that that's, I think, not a real popular statute for a lot of us in this room. So, but I think around sort of the permanence of some of those issues, I think from an economic perspective, there probably is a lot of uncertainty around how long some of those issues will last. Though I think some of them are political, and there is a more likely, hopefully, solution to that. And the disruption to SNAP benefits, firing LIHEAP staff, and really fingers crossed the healthcare subsidies, and figuring out how to protect consumers from the financial harm that arises from those particular problems. Hopefully, won't persist forever.
Yeah, thank you. Okay, as an economist, my understanding is this income gap issue is heavily discussed since 1990. It's not getting better. So I don't know why it is becoming political word, but the K-shape, I think probably you heard that people who's doing well will doing really, really well, and the other half is doing really, really bad, and it's getting exacerbated. I think this is a known economic issue since 1990, and it's getting worse and worse. That's why I had a concern that I think one patchwork potentially, and even I don't know whether we have a statutory, the legal ground to do that, but set aside that issue. But that's why I said we may need more permanent solution rather than this a rate case by rate case solution. So, but I think this income disparity between the top and bottom is getting worse and worse. I think that's a fact. And that's why a lot of time we are talking about affordability. I think it's not fair to blame just utility, because affordability is a ratio between energy rates and income. Income is getting worse and worse. That's why we are getting this more. Yes, some possibility is sometimes we have to make sure that utilities are accountable. But also, I think a lot of time they have to do certain utility work to make sure that we have a reliable service. So this is not an electric case, but the electric side, we have a different thing going on, same thing. That's why I have a concern that I think we are discussing this at the rate case rather than we have to discuss in the bigger and different location to discuss this issue, not here. But thanks for your response. So, and then how about the OAG?
Chair Sieben, Commissioner Hom. So as outlined, I can't commit our office to anything regarding a legislative solution. I do think that in the past, the commission has been able to look at the data points in front of it and try and catch up, so to speak. And I think looking at that here, as Cub brought up, and as we put in our attachments to our reply comments, the political situation is evolving, especially with healthcare costs. I think also a historic government shutdown is a factor in a furlough. And looking back at all the prior cases, that's what the commission and decision makers have been able to use to try and address that affordability issue. And so I think the decision makers, if they're able to address those various data points, that's kind of where we're at right now.
Okay, under that concern, does it have any impact to the industrial customer or the general service customer of that political circumstance you just mentioned, that change in the SNAP program and the potential LAHI fluctuation? Does it have any impact to the general service or industrial customer?
Chair Sieben, Commissioner Hom, that's a good question. I think in those instances, that has been the company's decision to try and assist those customers and to make sure that those customers weren't going to leave their system.
Okay. And then another question is, even among the residential customer, do you think every customer will have a similar problem with that political issue, or the potentially bottom 20 to 40% of the income group is having that issue?
Chair Sieben, Commissioner Hom, I'm not an economist, so I don't feel like I can comment on that.
Okay, so potentially who is qualified for the Affordable Care Act insurance premium category, and probably that top tier people may not need that one, and a lot of people has company paid insurance. I don't think they'll have that problem, right?
Chair Sieben, Commissioner Hom, I think I would defer a little bit to the department or to Cub. I don't want to get out over my skis.
Commissioner Hom, I think that's a great point and an important point, is that no matter what threshold or cutoff point we set for some sort of remedy to these types of problems is it's going to be necessarily over and under inclusive. You're going to have some customers who don't need it. You're going to have some customers who really need it who aren't getting enough. And that's a fundamental problem of any governmental program design, any law that has an exception or a threshold. I think the question before the commission is, with the tools that the legislature has given you right now, on the record that's before you right now, what tools are available to help customers who need it? And I think that what OAG, CUB, and the department are saying is we think that there are good bases to find exigent circumstances to reduce rates for residential customers. Could there be a more precise or exacting solution that if we had a lot of time or we got additional legislative authority to do something else that we could craft? Almost certainly we could do that, but that's not an option for the commission to do right now. Your option is to find exigent circumstances based on the record before you. And I know that isn't always a satisfactory answer, but that's just sort of where we sit.
Okay, thank you.
I think that was a helpful exchange. I think that the challenge is, like, on the one hand, we're hearing you should find exigent circumstances because the legislature gives you that authority to find exigent circumstances, but everyone also is sort of skating over the definition of the word exigent at the same time. And so I don't personally think we can find exigent circumstances here and appreciate that the affordability concerns that customers are facing are something that are very serious and we need to find solutions for. But driving to the factors that are causing the company to ask for the increase in rates here, I found the table or the chart on figure 1 of Excel's initial filing. It's in volume 2, or wait, now if I shut it, I'm not going to be able to find it again. It's in volume 2 on page 5, Librikowski Direct. There's a graph that shows all the different drivers here. And Mr. Dobson, I'm curious about if you can give more detail. It's probably in here, but I didn't get that far into it. Your investments in your fire safety systems at your gas peaking plants. I believe those are in Maplewood and
Westcott.
Westcott. Are those the same peaking plants that didn't operate during Winter Storm Uri? Do you remember?
Westcott was.
Westcott,
Yeah.
I believe, was. And my question here is there any, I don't know what investments in fire safety systems mean. Probably means that the plant won't catch on fire if there's a fire, or it will help suppress the fire.
Yeah, Madam.
But are those investments going to lead to more reliable plants? Because, or is it simply like a fire suppression system where it puts out a fire? Do you know? And what I'm getting at is there were significant costs to your ratepayers during Winter Storm Uri when those gas peaker plants weren't operational, and instead the company had to go out and buy gas at really high prices that we all don't really want to recall that economic impact to ratepayers. But I'm trying to see if, or kind of test what this cost is and see if it ultimately, these types of investments that you're making or saying that you need, will it actually lead to the deliverability of gas when people need it? Or what else can you tell us about the fire suppression systems?
Madam Chair, I'll take a shot at it, but Liz will know more details. I think that the general answer to your question is yes. It's going to result in we think is a more reliable peaking plant that can deliver when is needed. Really, to get into there's another piece to that too. There's an upgraded control room that's being added at that plant too, which we think will also increase the reliability of that plant. The fire suppression system, we had one in the last case, we have another one in this case, is also reflective of the fact that the fire suppression systems in those plants were, I think, 1950s, 1960s vintage, and so they obviously the safety codes have changed since then, and we needed to provide some more redundancy in order to, like you said, make sure that if there is a fire, you've got it's a gas plant, you got flammable stuff all over the place, and to
I'm
make
sure there's already some sort of
there is
sprinkler system.
It's an upgrade,
but this is an upgrade that sounds like it might lead to continued safe operation, or it should lead to safe operation of the plant. But I think in a time of like really the need to drive down on what are the most prudent investments to make, I'm trying to get at, like, is this really necessary for the deliverability of affordable gas? Ms. Brahma, anything additional to add on that? Or, sorry, go ahead.
Thank you, Chair Sieben, Commissioners. I agree with everything Mr. Dobson said, certainly. These investments are required for both safety and reliability, and to comply with code, with laws and regulations that govern the operation of these plants. And so the work here will help protect employees, it will help protect the public, it will also help ensure that the plants can stay operational in the event of an incident. If there weren't the higher quality suppression systems, those risks are much higher of what could happen, both from a safety and reliability perspectives. And the additional, these were not undertaken just to have nicer suppression systems. They were undertaken because they were needed for the safe and reliable operations of the plants.
And they're not recoverable under the GUIC just because they're gas peaker plants, or do you know?
Chair Sieben, that's our understanding, is that the way the GUIC is currently structured, it does not apply to these types of investments in gas production facilities.
And then a significant driver in your deficiency too is the increase in property taxes. And setting aside the error that was cited before, why are property taxes leading to an increase in like almost $11 million, it looks like? That seems like a really big increase in property taxes over a short period of time.
Chair Sieben, thank you for that question too. So the increase in property taxes for utility is a combination of increase in plant investments and then the rates established by the Minnesota Department of Revenue in coordination with the Department of Revenue to determine how much tax the utility will pay in a given year. These are largely outside of the company's control in terms of the increases in the tax rates. Those are set by the state. And so that is not... So that's really the driver. It's the sizable increase of the rates applied to the utility's overall plant.
Okay, and then the other sections in here are pretty easy to understand, or I'm sure will be developed more in the rate case. And I guess what I'm getting to is the deficiency overall of, in excess of 60 million versus the stay out proposal, which was less than that, and I appreciate. Is there any opportunity that the parties can work towards a settlement in the rate case relatively quickly? Because, setting aside interim rates, that discussion, that those interim rates by statute will take effect, as we know, in January, in the midst of the coldest part of the year when people are already struggling to pay their bills. If there can be a settlement between parties sooner rather than later, could the commission then implement final rates on a shorter time frame than a full contested case proceeding? And do you think that's possible?
Madam Chair, I don't see any reason that couldn't be, and we're obviously willing to work with the other parties and see if we can get there quickly. We're willing to take that up and try.
Mr. Dornfeld, and I'll turn to the other parties. Is this something, like, do you have the bandwidth to work on settlement discussions now, or do you have like a strong preference for a entire contested case proceeding, or do you want me to be encouraging this of Excel or not?
Well, we think you should encourage them to settle, Chair Sieben. Chair Sieben, to be serious with you, the department's always interested in settlement if there's a good settlement to be had. I don't want to sit here and promise today that that's going to happen. I'd note that a lot of the recent gas cases have settled, so that certainly makes us optimistic. But whether the department agrees to a settlement or not, the department's chief focus is ensuring that customers pay just and reasonable rates and no more, and whether that's achieved through settlement or through a fully litigated rate case, that I think the department's prepared to do either.
And sorry, I should have asked Mr. Dobson before, like, one of the drivers of your deficiency too, that I forgot to mention, is your increase request for a higher ROE. And, given that the Fed just lowered interest rates yesterday, you might be like, that might not be working in your favor for an increased ROE. So I would hope that request too, which is a pretty significant, again, $8 million out of your overall request, that's something you could be reasonable with on settlement discussions too. And I'm sure the answer there is you'll be willing to discuss the ROE that is significantly higher than our last settled rate case as part of settlement discussions, correct, Mr. Dobson?
Yeah, Madam Chair, when we would negotiate, we would be looking at all issues, and that would obviously be one of them in any settlement discussions.
Okay, thank you. Sorry, I forgot that. And for CUB and then the other parties on settlement discussion possibilities.
Thank you, Chair Sieben. Yeah, I would echo exactly what Mr. Dornfeld said, that we're always open to discussing settlement, but also are wanting to be strong advocates for ratepayers. And I think, just to be blunt, I think that ROE number is way outside the bounds of where we would settle at right now. So,
Chair Sieben, as with the department, we'll always entertain settlement discussions, but settlements do need to be supported by substantial evidence. So we have a litigation schedule that we can plan to move quickly with, but we do need time to review everything and make sure that we don't miss anything then that ratepayers are then penalized for.
Sure. And Mr. Pranis, recognizing you're not yet a formal party, but if you file at the CAH, then I assume you would want to be part of settlement discussions as well?
Yes, thank you, Chair Sieben, Commissioners. Absolutely, we have participated in past successful settlement discussions and would be happy to do so again.
And again, like, the driver here is, I know you're all very busy and there are a lot of rate requests in front of the commission, and we want to ensure that the end result results in just and reasonable rates for customers, but we're also all feeling the pressure of affordability on Minnesota gas customers, and we need to look out for the customers and what the end result is as best we can. So hopefully there could be settlement discussions which would result in interim rate requests that would be lower than, or that the end result would be lower than the interim rates that I unfortunately feel like we're going to have to implement here today. So that's what I was thinking, Commissioners, in terms of the overall case too. Like, we have to accept it. That's what the law requires us to do. We really rely on the parties to dig deep, and the Office of the Administrative Hearings to come back with a good report, or to find a settlement, and hopefully that would result in just and reasonable rates as well. Commissioner Tuma?
Yeah, Madam Chair, thank you. I want to dive a little bit And I appreciate that. I can check off my Bertram speech. You got it. I want to talk still a little bit about exigent circumstances, Mr. Dobson. And I don't view that Otter Tail was in any way, precedent. I mean, it's what it is what it is, but we had some comparisons to it today. And yours is somewhat different. They agreed to increase a provision in their existing rates that allows for low-income people to get lower bills. And so there was something already built in there to kind of address some of the challenges that were identified earlier. Is that, if you do exigent circumstances for everybody benefits from it. Otter Tail had this proposal that targeted it somewhat and made that more palatable. In addition, they've been out for 5 years, and so when you looked at the inflationary impact, they were significantly below the inflationary impact for rates and for bill impact. Now, to their benefit versus you're only at 2 years. They had 3-4 years ago when inflation was way up, and so it was easier for them to get under the CPI. And I usually kind of try to use that CPI a little bit just to kind of weigh this for you. And so out 2 years, and it looks like you're a little bit above the CPI, not much. Again, back of the envelope, ask AI to solve the problem for me. It's 6.8 versus 6.5 is where it's at. So it's a little bit, you're a little bit higher for your rates. The one that's going to be more challenging for me, unlike the electric bill, which is impacted by gas price, but even yours more so because it's a direct pass-through as opposed to just one of the inputs into the cost of energy coming out of MISO for Otter Tail, is that gas prices seem to have gone up quite a bit from when your last interim rates went into effect. I have almost double according to Henry Hub, but that's, the numbers can be very, very deceiving. Did you do a calculation, and this is what I asked Dakota Electric, and they gave me some, been rough numbers, but calculation of bill impact from your last interim rates, which went into effect January of 2024. What is the bill impact now for a average residential ratepayer when they see these interim rates go into effect, both gas and rates? What's going to be the impact? What are they going to see as their bill? 2 years ago, I was paying X. Now I'm going to be paying this amount after the interim rates go into place. Do you know that number or have somebody that does?
Yeah. Commissioner Tuma, if I'm understanding the question correctly, I think our residential customers are looking at about $5.84 increase. That works out to about 7.1% total bill since 2 years ago in our last case.
7.1. So a little bit more than inflation than they have, but we're not talking about twice as much as inflation.
No, and actually, if I could speak to that, because I understand that point. I think that the other piece, just to put out there, is we've acknowledged we're sort of in a period here of a lot of capital investments, and we've said in our case that we think we're coming to the end of that, and so that's a short, it's a window. I mean, obviously, we didn't have a case from 2009 to 2021, and now we're here again. But I think sort of looking at those capital needs, to be as close as we are to inflation, we are a little above as I've understood, but we're pretty darn close, and I think that it's an important point.
Thank you, Chair Sieben. So in that discussion, what is the impact from commodity cost increase from 2 years ago to this?
I'm going to have to phone a friend. Madam Chair, Commissioner Hum, I don't think we know. So I don't think we have that right now. If there are other questions, we can try to get back to that one.
No, I mean, thing is, yes, I think public doesn't see the difference between what companies are trying to increase versus overall cost, which include commodity cost, which is outside your control, except your hedging behavior. So I think we still need to scrutinize your hedging activity to make sure that you are trying to protect ratepayers. But if overall commodity is going up, price, I think that's what's happening. Now I think Henley Hub price is, as you mentioned, like a $4.50-ish, hitting $5. And that's outside your control, except the hedging portion of it.
Sure. Madam Chair, Commissioner Hall, my understanding is our gas buying, our gas purchasing is subject to other dockets. So you do review that. That's not in this case, but it is something that you guys are reviewing for us consistently.
Yeah, I mean, when people are talking about affordability, I think it's all inclusive, and they don't distinguish between your distribution cost or interstate pipeline cost. They do care final bill, right? So that's why I think a lot of time, I think we are trying to control your portion of the bill. However, at the end of the day, overall bill can go significantly higher than people wish. But that portion, significant portion of that is due to the natural gas price, which is totally outside our control.
I agree with that, yes.
Just to follow up on that, Mr. Dobson, on page 21 of your Volume 2 filing, there's a Figure 3 that is a citation from the Energy Information Agency that shows the residential average rates for natural gas service of IOUs in the upper Midwest. Would that, and NSP Minnesota is towards the bottom half. It's below the national average. But I think why this is interesting is because it's like other cold climate states, right, that use gas and are subject to the same gas prices. Would the average rate chart look the same for average bills in the same set of customers? Because the rate is one thing, but I'm not really sure how it translates to the bills comparison for like situated gas utilities in this area. Do you know that?
Madam Chair, I don't know, but I think that's a really apt question because, obviously we've got, usage is a big issue. This is an issue in the electric case as well that we're talking through. The different use of riders. I don't know how our bills compare, and obviously you're right that these are all cold weather states, as I think we all know. That line of latitude means a lot in terms of how much gas you're using between Iowa to northern Minnesota. But I don't off the top of my head have a bill comparison, but we can try to look at that.
Yeah, I just think it's interesting because what we're all trying to get at is that people pay the lowest bills possible. Right. And again, not to hit on the topic that traumatized me the most as a commissioner, but Winter Storm Uri, the bill impact for customers was very significant. And what we can do, not necessarily in rate case dockets, but what we all need to collectively do is help ensure that we're building a reliable system that people get the gas delivered in an economic way, and it shows up when it's like the weather we're going to have this weekend when it's minus 20 and people can stay warm in their houses. And so the bills that people pay are very important, obviously, for affordability and all sorts of reasons. But we also have to ensure that we're investing in a reliable and efficient system so that people don't die when it's really cold out. So it's a balance, and I know that all the parties here understand that. And it's just something that I think, too, we are increasingly vulnerable. Not just I think, I know we are all increasingly vulnerable with more winter extreme weather circumstances and what it means for bill impacts on customers when there's increasing costs for natural gas in the markets and what that means for customers' bills. It's something we should all worry about and collectively try to put in place good, strong regulatory controls to shield customers from those price spikes that unfortunately are more likely to come in the future. So maybe I should get off my horse here, high horse, and back to the actual, any other decisions in the rate case. One, the question I had for the department on decision option 11, again, this is requests for specialized technical services. We're happy to do it, or at least I am happy to do it. This is so that the prepaid pension issue can be more further developed just in this rate case. Mr. Dornfeld, is that right? Or is that like the fallout from the cumulative rate cases where the prepaid pension asset is still kind of up for consideration?
Chair Sieben, commissioners, that's part of it. That issue remains unsettled. I think the other reason why the department likes to have this authority is sometimes rate cases present specialized issues where specialized expertise is appropriate. And so, the prepaid pension is one that, and the related accrued retired medical and post-employment, I think Nancy told me it's called OPEB.
It's loyal on the side.
It's essentially to hire an outside expert.
Hire an outside expert for that. And then the including but not limited to language ensures that if there were some other issue that popped up, we wouldn't have to come back to the commission and ask for additional authority.
Commissioner Hom.
Thank you, Chair Sieben. Yeah, I was going to mention that what I heard from our staff on the electric side, they are developing a record pretty well over there. And I'm supporting this department need extra help to develop the better records because I think Excel spreadsheet from the utility is not evidence. I need to see a lot better evidence than just Excel spreadsheet company claiming that we use this money this much. I think we need to go into every detail of this record to making sure that ratepayers are not paying twice.
Other questions, commissioners? Commissioner Hom, do you want to take a break, or are you ready, or does anybody need a break? We can move to deliberations.
I can make a motion and to see how it goes.
Okay.
So I'd like to make a motion to move decision option 1 5 So 9, I think we may need to adjust the dates because there was some concern that commissioner may not get enough time or commission staff get enough time to, I think, digest overall result from the contested case. But I think I'll just move as it is for now.
You want to do 7, refer to the ALJ or OH?
Okay. Oh, yeah, yes. Sorry.
5, 7, and 9.
Yep.
And that's actually now, should be the Court of
Administrative Hearings.
Yeah.
And then 10 as modified. And 11. Thirteen, 14, 19, 20, 'and then I will discuss a little bit about 22, but for now I'll just move 22, 23, 24,
Assuming all subparts of both of those.
yes, and 25, 26, 27 as modified, you suggested, right?
Yep, just say email notice on, probably after bill insert on 25. Got it.
And then not 27, you're saying? Instead, it's under
No,
the,
no, do 27 also.
okay. 25, 26, 25 is modified, 26 and 27.
So rationale for, I think, overall is I do not see this exigent circumstance in this case. I understand there is a hardship, but I think, to me, it is more ongoing circumstance in the macro level issue. We may need more permanent solution through the legislative resolution rather than this interim rate decision-making process. But I'm not strong in that position, but I think at this point, that's my position. And then also 22, I think this is a negotiated rates. So if Excel decide to not to recover that one, as long as it's not going to be owned by other customer class, I think I have no concern. But if there's any legal concern, I need to talk with our legal staff, I think, because one of the parties said there is a legal issue. So that's why initially I'm moving it, but I think I can talk with our staff on the legal issue on that one.
I think we've done it this way in the past, is my recollection.
Yes, that's my understanding too.
So I didn't think we thought it was a concern then. I understand now exigent circumstances is an argument, and people are looking for comparisons of why it should be exigent circumstances in this situation. But I agree with you. This was closer than Otter Tail in my mind, just because it is slightly more than the CPI, and so that kind of is a point at which I gravitate to where I need to take a closer look at it. And the numbers are about what I suspected as you laid out when I looked at the record. And again, did the back of the envelope, which is not in the record, so you're always going to be careful with that. But I felt in this situation it was good enough. It was in that we didn't really need to get into exigent circumstances. But definitely it was a closer call than Otter Tail was last week. So that's the way I look at it. So I agree with you.
I have a question, Commissioner Hom, on 10E. I guess my question is that's consistent with the company's filings in their application. They were talking about their net zero energy, being a net zero energy provider by 2050. And I saw some of that, and I think it works well with the efficient fuel switching gains that have been made recently. So I guess I just wanted to ask Excel first. You're comfortable with 10E, that language?
Madam Chair, yes, I look at this as you're asking development of the record on this issue, and we're fine developing it. I don't have any concerns with the language.
Okay, sounds good.
So decision option 9, I'm okay as it is for now, but if any commissioner need extra time at the end of the whole rate cases, do you want to push a little bit back on the ALJ, the report timeline? Or personally, I'm okay, but I think there is some concern by some commissioner that we may need the extra time to think about this overall, because we are the one making the final decision. We don't want to rush through the brackets.
In Commissioner Hom, sorry, I didn't really think this through ahead of time, but if we adopt either, or I didn't talk to staff, if we adopt 8, we're asking for the report back by June. Does that mean that that final rates would be implemented at a different time? Yes, Mr. Dobson?
Yeah, Madam Chair, I think just the difference between 8 and 9 is 8 is the 10-month rate case schedule and 9 is the 13-month, because you have a separate rate case going on, so you have the right to extend it out.
Yeah, party agreed the extension, that's the 5. Mm-hmm. So I think because of 5, but we are using the extra time, but I want to make sure that every commissioner has enough time for the final decision making. That's why I'm more open to revise it if any commissioner wants extra time to push back on the ALJ process to be completed before a certain time frame, so we can have extra time.
I don't think I was asking for it, but I was more concerned, like, if we pushed it back, then hopefully the customers will get a refund, so we want to get it done sooner rather than later too, but I don't know if this is about a different issue.
So that's why I like your statement and Commissioner Tuma's birch room, that if party can settle quicker, and then we don't have to spend all time, right? Even if we give the time frame, then you don't need to spend whole time.
So
this is a worst case scenario.
Yeah, I mean, Madam Chair, Commissioner Hom, I think two different ways. As obviously, we were asked to consider settlement quickly. So whatever schedule
with a lower ROE,
whatever schedule you select wouldn't theoretically affect that if we were able to get something. What this would do is, depending on which schedule you decided, the OAH is going to, when this gets to the OAH, then the OAH is going to set a schedule that aligns with that. So you're going to get your report later, obviously, if you select option 5 than if you accept option 4. The amount of time you take to process that report and get to a final decision is obviously up to you, but that's the part that would be affected.
As I see this, the worst case, we go all the way through litigation and go to the end of the timing here. If I'm understanding, likely we would be putting final rates into implementation. It's probably the first of 2027.
Correct. It'd be early 27, yeah.
So, that's we're into the heating season, but not, they will be getting a discount basically at the beginning of when the bills are the highest. So
you hope.
We hope. Again, that's the worst case scenario. Mr. Dornfeld looks like he's thinking and contemplating life. It schedules.
Something like that. Chair Sieben, Commissioner Tuma, one thing that might be helpful in the referral order would be to instruct or request that the ALJ, in the event that a settlement is reached, to refer the settlement to the commission on an expedited basis or without adopting a recommendation. What we've seen in the last several rate case settlements is that the ALJ chooses, understandably, because they have other obligations, to issue a report reflecting on the settlement on the original rate case schedule. So we might have reached a settlement, 3 months earlier, and the ALJ still puts out the report thereafter, and so it doesn't get back to you as fast. The other thing I would say is, it's not, I won't bore you with the logistical details, but it's not really feasible to do a full contested case in probably less than 8 months. And if you adopt decision option 8, you're going to, basically the record development is going to suffer because everything is going to get collapsed. So strongly encourage decision option 9.
And then what was that language again for the request that the,
In the event that a settlement is reached, request that the ALJ expedite the re-referral of the case back to the commission, something like that, to make clear that if a settlement is reached, the ALJ can shouldn't feel obligated to write like a full report and just get the settlement back to the commission.
That's the question I would have on that. At what kind of settlement? All party settlement?
yeah, that's like a black box versus another. Yeah.
I would an all issue, all party settlement. Yeah. I think would be the way to describe it.
Because I mean, to me, so long as I have, OAG. No offense to Cub, but as long as I have the OAG and Doc signing on that would be enough for me. That still gives people room to object to it.
That's one of those things you shouldn't say out loud, Commissioner Tuma.
I did show up at your fundraiser, so just remember that.
Oh, boy. That too. Just kidding. Okay, well, our order writer can get that language right in the referral, right, Ms. Kaler?
You want that's my question is, do you want an all parties then? Is that all parties, all issue?
To me, yeah, it has to be all party and all issue. And I think that's why I like the Dakota Electric settlement and the briefing paper, that they show us item by item and all party agree with it. So I think that is very helpful for me to make a decision on the settlement.
Yeah, so again, we'll include language about if it's an all-party settlement, then the report back to the commission should be expeditious, or something along that line, so that we can hopefully implement
I think it's a good idea.
lower rates as soon as possible before the heating season with a lower ROE. Just kidding. Okay, I mean,
No, you're not
now
kidding,
I
right?
shouldn't say that. Okay. Anything else, or should we?
No, I
did
think
we
that based on what I heard from Commissioner Tuma, I don't have any concern on that item 22 anymore, because there was some concern with the legal, but I think if you have done that before, I think I can skip that consultation with our legal.
Comfortable with it.
Okay, is there any question on the overall, or any discussion amongst commissioners, or do any parties have any problem with the motion that you need to tell us about? Mr. Edstrom?
Thank you, Chair Sieben. Just a small point on that, and I'm sorry for not raising this earlier, but on the email notice, just raising for your consideration whether you'd want to make that language consistent with last week. There was a little more detail in the decision option last week about sort of contents of what the email would have. Just
I think now it would be under the executive secretary would sign off on it, so.
And I would strongly advise Excel to consult with our CAO if they want our executive secretary to sign off on it. And that was basically, you did have some details there, and we just wanted to work off of what was in the details of the briefing paper at that stage. But I think those, in my mind, would be instructive to Excel to make sure are included in any notice that they want CAO to sign off on. So I don't think we need to change it, but thanks for pointing it out and emphasizing it.
Okay, any other discussion? Otherwise, we'll proceed to vote on Commissioner Ham's motion. Commissioner Ham?
Yes.
Commissioner Tuma?
Yes.
I also vote yes. The motion passes 3-0. Thank you, everybody. We're still not done.
We're still not done. I forgot about that. Yeah, we got
One more item.
one more. Number 6. I was already packing up to go.
Are you ready? Yeah, okay. No, it's okay. Ms. Pham, when you're ready, please introduce our last item.
Thank you, Chair Stephen and Commissioners. The last item, number 6 today, is docket number G-002/MR-25-357 in the matter of the petition of Xcel Energy for approval of a new base cost for interim rates. The issue before the Commission today is, should the Commission approve the proposed new base cost of gas? And staff and parties are available for questions.
Thank you, Ms. Pham. We'll begin with appearances by the company and then the department.
Madam Chair, Ian Dobson with Xcel Energy.
Elizabeth Brahma Taft on behalf of Xcel Energy.
Nancy Campbell with the department, and online I have Mark Johnson and Sachin Shah.
Okay, Commissioner Hahn.
Thank you, Chair Stephen. So I think I already asked you the question here. I compared your base cost of gas as of now and then this proposed one. There's a significant changes. And then I know that Henry Hub prices are significantly up compared to last year. And then I think even the MISO meeting, I think independent market monitor mentioned about 40% increase in natural gas costs in general in MISO footprint. So I don't know exactly how much it went up in your case because you are doing your own hedging. But two concerns in overall, I think a demand entitlement, I think we need to really scrutinize that more because that's one we can control to make sure that no additional charges to the ratepayers. We cannot control their rates because it's an interstate pipeline, but at least we can control how much we are procuring it. And then that doesn't mean that we can sacrifice reliability, but we want to make sure that extra capacity we are procuring for reserve margin is not being used by your non-firm customer or any of the sorts of those kind of thing. And for foreseeable future, I think this natural gas price will stay between 4 and 5. So I think we may have to change, I think, your understanding of your hedging behavior. I think it used to be a $2. Then downside is very limited, but upside was a lot. But now it's a 4. I think now you have to worry about both down and up because we have seen the $2 gas many times, but given the fundamental, the LNG station is being built and they are trying to export to Europe. We may not have that circumstance, but I think now hedging, because hedging also costs money, that buying the hedging mechanism is also costing money. So we may need additional extra scrutiny on overall on this. I think other than that, I think the department and the company agree on this, so I don't have much, but I just want to make sure that I think we have other docket, demand entitlement dockets, and hopefully the department is doing annual hedging discussion with the utility, not only gas, the Xcel, but the CenterPoint to make sure that we are fully vetting their activity in the demand entitlement and then their hedging, because hedging can protect the ratepayers. And then also we shouldn't overspend on the hedging. The same thing with the demand entitlement. So other than that, I can make a motion unless other commissioner has
One quick question I had for Xcel is this includes your costs for storage too. And there had been discussion previously, and I've just seen in the trade press that other states are investing more in storage of gas. That's still a consideration, but nothing, obviously it's not penciling out to pursue any more gas storage contracts or expenditures that are of note. Mr. Dobson?
Madam Chair, honestly, I don't know where we are in those discussions. I haven't heard anything about adding storage, so that's kind of my assumption that it's not penciling out right now, but I will admit I don't know, but I will try to find out.
I think too, it will likely, or that discussion will come up in the IRP that you're filing.
Yep.
Is that due in this winter, or is it, I think it might be in 2026.
It's
It might be
definitely
this
coming
summer.
up. I know that, but I can't remember when it's filed, but I know it's coming up because,
Mhm.
yeah, we're starting to get that rolling.
But some
So
of
we
the
can-
overall, like, ways that the utility will be able to manage the overall cost of gas, those will certainly be discussions that you'll be having in that filing. And Ms. Campbell, anything to add on this overall, as we're seeing, as you know, and Commissioner Hahn pointed out, as we're seeing cost of gas go up nationally, like any other good things that we should be thinking about or discussing here?
I think you've mostly, I think Commissioner Hom has mentioned most of the ones. We are looking at the demand entitlements and the hedging dockets seriously, and we do have some demand entitlements, I think, pending before the commission at this time, so.
Okay, that's all I had. Thank you, Commissioner Hahn.
If there is no other question from Commissioner, I can make a motion. So I'll move decision option 1 and 3.
Any discussion? Then on Commissioner Ham's motion of 1 and 3, Commissioner Ham,
Yes.
Commissioner Tuma.
Yes.
I also vote yes. The motion passes 3-0. Thank you. There's no other business before the commission, so we are adjourned for the day. Thank you, everybody.
Thanks for using WebEx. Visit our website at www.webex.com.
www.